Good morning and welcome this is the first day of the hearing in exit case number ARB 2019, Campos de Pesé S.A. versus Republic of Panama. On behalf of the Arbitral Tribunal, Eduardo Zuleta speaking, and Professor Brigitte Stern and Professor Horacio Grijera and the Secretary of the Tribunal, Mr. Gonzalo Flores. Welcome, and as a starting point, I would ask the parties to briefly present the team on the table, starting with claimant.
Thank you, Mr. President. Good morning, members of the Tribunal. Good morning, colleagues. To my left, we have Ryan Knecht. Sorry, I said that in the German. He pronounces it Connect. He's from Core Graphics. He's assisting us with the technology and the PowerPoint presentation today. I'm James Boykin, partner at Hughes, Hubbard & Reed. To my immediate right is my colleague, Eleanor Ernie, also of Hughes, Hubbard & Reed, and to her right, Mr. Nicholas Swerdloff of Hughes, Hubbard & Reed. Then we have, next to Nick, legal representative of SIR. And then we have two associates, Alexander Afnan and Shada Vance from Hughes, Hubbard & Reed, and James Nance, a summer associate with us this summer. And the remainder of the delegation are our expert witnesses, beginning with Jaime Mora, who's an expert on Panamanian law, Mark Olson, claimant's expert on Delaware law, Christopher Dutton, claimant's expert on the law of the British Virgin Islands, and then Henry Mander, claimant's expert on the law of the Cayman Islands. That's our delegation. Thank you.
Thanks so much. Respondent.
Mr. President and members of the Tribunal, good morning. Speaking is Daniel Pulesio, of the law firm of Greenberg Traurig on behalf of the government of Panama. To my right, you have Margie Liz Jaime, a representative of the government of Panama, from whom you will be hearing today. To my left, you have my colleague Tomás Solís. He will also be speaking today during opening statements. You have Catalina Brito, one of our associates, who will be taking the lead on some of the direct examinations throughout this hearing. And then you have Ryan Fulgham, our paralegal, for support during this hearing. Thank you.
Thank you. Any administrative matters the parties would like to raise before we start? Claimant.
Hope it will please the Tribunal that we have none.
Respondent.
Likewise, nothing from us.
Thank you so much. So we give the floor to respondent for the next hour and a half.
Thank you, Mr. President. We will first give the floor to Margie Liz Jaime from the government of Panama for an opening statement.
Good morning, Mr. President, members of the Tribunal. It is an honor to appear before you today on behalf of the Republic of Panama. Before starting my intervention, I wish to make the following statement on behalf of my government. The Republic of Panama regrets Mr. Pelez's decision not to appear here today before this tribunal. We are here today because Mr. Pelez encouraged this international arbitration against Panama, which has devoted substantial resources to be here today to respond to Mr. Pelez's accusations. And it's regrettable that Mr. Pelez decided not to appear in support of his allegations. Therefore, the Republic of Panama will be asking this tribunal in an appropriate time to pay the cost of this phase of the proceedings. In addition, Panama respectfully requests the tribunal that Mr. Carlos Pelez's witness statement and Mr. Ernesto Palacio affidavit be struck from the record in accordance to Section 18.6 of the Procedural Order Number 1. Mr. President, members of the Tribunal, the primary purpose of my intervention today is to briefly talk about how Mr. Pelez and the Pelez Group always represented themselves being Nicaraguan and never Italian. Their alleged Italian origin came as a surprise and was revealed for the first time when Campos de Pesé commenced this arbitration under the Italy-Panama BIT. In other words, Mr. Pelas and the Pelas Group created the expectations in the Panamanian government that they are Nicaraguan, and at no time did they present themselves as Italian investors. For example, in a 2009 Forbes interview with Mr. Pelas in Managua, candidly entitled Navigating Nicaragua, where Mr. Pelas talked about the sale of background magnet to General Electric, Mr. Pelas is described as directly involved in just about everything in Nicaragua. For the tribunal's reference, Mr. Pelas' first interview is Respondent Exhibit R004. Mr. President, members of the tribunal, the fourth interview aptly describes the commonly held view on Mr. Pelas all across the region. He is a well-known Nicaraguan businessman involved in almost everything aspect in the life in Nicaragua. Nobody in Panama or in the region generally recognize Mr. Pelas and his group as other than Nicaraguan. Forbes, of course, interviewed Mr. Pelas in Nicaragua, not in Italy. Similarly, at page 4 of an October 2011 presentation supposedly made by Campos de Pesé to the Minister of Energy concerning Grupo Pelas' experience in Nicaragua in the biofuel industry for the project at issue in this arbitration, Grupo Pelas expressly described itself as Nicaraguan. For the tribunal's reference, this presentation by Campos de Pesé is Claimant Exhibit C019. Later, in June 2012 presentation to the Ministry of Energy, Grupo Pelas again described itself exclusively as Nicaraguan at page 4 of the presentation. For the tribunal reference, this presentation by Campos de Pesé is Claimant Exhibit C081, Annex 4. In subsequent presentations, Grupo Pelas never identified itself as Italian. For example, in a December 2012 presentation supposedly delivered to the Presidency of the Republic of Panama, accompanying claimant's memorial, Exhibit C015, there is no mention to Grupo Pelas as being Italian. Furthermore, in 2014, Campos de Pesé unsuccessfully applied in Panama for benefits under Law 54 of 1998, which provides legal stability to investments. But importantly, both domestic and foreign companies can apply benefits to this law, under this law. However, Campos de Pesé applied as a domestic company. In other words, it did not even apply as a foreign company, not even an Italian one. For the tribunal reference, the papers concerning claimants' unsuccessfully application is in Respondent Exhibit R003. Pelas specifically never held himself out as Italian to Panamanian authorities. Ideal Living Corp., a Panamanian real estate company in which Mr. Pelas is a member of the board of directors, files a standardized annual reports before the National Security Commission of Panama as a requirement because it is an issuer of corporate bonds. In Ideal's annual report, Mr. Pelas is described as a national of Nicaragua. And for example, you can see this in the 2013 report, and as a national of Spain in another report in 2019. For tribunal's reference, these reports are Respondent Exhibit R005 and R006. At no time Mr. Pelez represented himself to the National Securities Commission and to the public in Panama as being from Italy. Furthermore, I wish to note that Mr. Pelez never used his Italian passport to enter Panama prior to the commencement of this arbitration in June 2019. Hence, the Republic of Panama respectfully submits that because Mr. Pelez never used his Italian passport at any relevant time for purposes of this case against Panama, it is must follow that Pelez must not be allowed to use it to sue the Republic of Panama. Therefore, and to summarize, Mr. Pelez and his relative have been investing in Panama exclusively as Nicaraguan and at best as a Spanish investor, but never Italian. Concerning the alleged investment in Campos de Pesé, claimant has told you that Mr. Pelez met with former President Martinelli. Mr. President, members of this tribunal, if Mr. Pelez has access to President Martinelli, it was because he was a well-known, famous Nicaraguan businessman, not because he was Italian. In other words, they conducted business in Panama because they are Nicaraguan and as Nicaraguans. Throughout claimant's years of presence in Panama, the Pelez never purported to invest in Panama as Italian investors. In Panama, no one knows they are Italians, at least not until now. Mr. Pelez purports to have first acquired an Italian passport at the age of 54 in 2007. Since that time, Mr. Pelez had never claimed Italian nationality to Panamanian authorities based on his passport, just as he's doing now before this tribunal. Mr. President, members of the tribunal, the Pelez are unquestionably Nicaraguan. They live in Nicaragua, not in Italy. They have no residency in Italy. They have no business in Italy. Finally, I wish to point out that there could be an agreement to treat Campos de Pesé as Italian for purposes of the second part of Article 25(2)(b) of the ICSID Convention, because it is legally impossible for a party to have agreed to something that it did not know. Mr. President, members of the tribunal, the Republic of Panama considers Mr. Pelez and his relative must not be allowed to defraud the legitimate expectations created upon my government, that is, dealing with Nicaraguans and not purport Italian nationals. The individual Nicaraguan nationals here could have attempted to bring this case directly as supposed investors under Article 25(2)(a), but they chose not to do so. And as Panama's Council will discuss shortly, the tribunal lacks jurisdiction because Campos de Pesé is neither under Italian control for purposes of second part of Article 25(2)(b), nor under Italian management under DBIT. Mr. President, members of the tribunal, with that I conclude my intervention, and with your permission, I will turn now the floor over Mr. Pulesio Boyk. Thank you.
Mr. President, members of the tribunal, good morning again. We're going to be covering today during our opening statement several issues, I hope relatively quickly and concisely. We're first going to provide an introduction to our presentation. Second, we're going to address the issue of Mr. Pelez's and Mr. Palacios' absence and the implication that that has on the evidentiary record. Number 3 and 4, we're going to discuss the relatively uncontroverted questions of burden and standard of proof and relevant dates. Number 5, I'm going to turn it over to my colleague Tomás Solís for the issue of nationality and specifically effective nationality. Then I'm going to take it back again for the issue of control and management and some final remarks on the witnesses that you're going to hear from throughout this hearing, claimant's misconduct throughout this case, and our conclusions. Our introduction.
Excuse me, sir?
Yes?
You can move your microphone towards you a little bit.
Absolutely. Is that better? Thank you. Tribunal, this is not a case brought by Italian nationals, as it is evident. This is a case that was purposefully brought by a purely local Panamanian entity. That purely local Panamanian entity chose to sue on its own name and on its own behalf, arguing that it is indirectly controlled and managed by citizens of Italy, but no citizen of Italy purported to bring a claim in this case. And what Campos de Pesé is attempting to do here is unprecedented. We have reviewed every single case that cites to or refers to Article 25(2)(b), and we have not seen any case that comes even close to what Campos de Pesé is attempting to do here. They are trying to have this tribunal deem Campos de Pesé as under Italian management and control simply by providing copies of the passports of some individuals without any connection of any kind between those individuals and the state of Italy. Number two, they are trying to argue indirect ownership via 3, 4, in some instances, 7 layers of corporations and convoluted structures of trusts. This would be the first tribunal to ever find indirect ownership in those circumstances. And last but not least, this group of alleged Italians never set foot in Campos de Pesé, never had anything to do with Campos de Pesé operations. How can they argue control and management? And that is with the possible exception of Carlos Pelas, who refused to be here to be cross-examined. When all is said and done, Campos de Pesé has failed to show the two things that it needed to show in this case. Number one, that this group of individuals is Italian for purposes of jurisdiction. And number two, that this group of individuals exercises indirectly or directly control and management over claimant entity Campos de Pesé. As to nationality, they didn't prove that any of these individuals actually met the requirements for Italian citizenship. They didn't show that these individuals didn't forfeit, in some cases, their Italian citizenship. For example, because they voluntarily acquired other nationalities, such as United States nationalities and Spanish nationalities. And last but not least, the area on which my colleague will focus, claimant produced no evidence of effective nationality and any genuine links with the state of Italy. Regarding control and management, claimant has tried to couch this as 3 different independent or separate avenues of proof through which it purports to show that this group of individuals allegedly exercises control and management over Campos de Pesé. Those 3 proofs fail at the legal threshold level, and they fail at the factual and evidentiary level. The first proof, put simply and distilled to its core, what claimant is arguing is that this tribunal should deem Campos de Pesé as under indirect Italian control and management because purportedly its ultimate final beneficiaries, or UBOs, have an Italian passport. Let's start with the basic fact. It is undisputed that Campos de Pesé, at least as of August of 2014, was not majority held directly or indirectly by citizens of Italy. Our expert, Isabel Kunzman, an expert on finances and mathematics, she reviewed the records, crunched the numbers, and made a calculation which claimant does not dispute. In the rejoinder, they said, we do not dispute the math of Ms. Kunzman. As of August of 2014, this group of alleged Italians did not hold more than 50% ownership interest in claimant entity Campos de Pesé. Now, yes, the parties discussed the issue of whether this group of alleged Italians indirectly owns a majority ownership interest in SER, the indirect parent entity. But that is largely an irrelevant question because SER isn't here. SER is not the claimant. Claimant entity is Campos de Pesé. But further, none of these individuals were ever involved in the operations of Campos de Pesé, with the possible exception of Carlos Pelas. The second proof, claimant would put it simply, it's, well, the majority of the members of the board of directors of SER happen to have an Italian passport. And that means that Campos de Pesé is under Italian indirect management and control. This would be the first tribunal to ever hold a purely local entity as under foreign control and management based on the nationalities of directors or officers of either the claimant entity or its direct or its indirect parents, which is even worse. A claimant cannot fabricate supposed foreign control and management by having citizens of a certain nationality in its corporate structure. But moreover, the individuals that happen to have an Italian passport in SER's board of directors, as we will see throughout this presentation, were by and large strangers to SER. They were strangers to SER because they did not have, either directly or indirectly, an ownership interest in SER. They were disconnected otherwise from SER and simply happened to have an Italian passport and were sitting at the board. Last proof that claimant argues is that Carlos Pelas, who isn't here to testify, has an Italian passport. It is undisputed that Carlos Pelas is not an owner, directly or indirectly, of any percentage of Campos de Pesé or SER. In the best case scenario, what Carlos Pelas has is a limited degree of control over a convoluted web of Cayman Island trusts that supposedly controls a company called Traverse Atlantic Corp, which itself owns 20% of SER. No tribunal has deemed, in these circumstances, a purely local company as under foreign control and management. When all is said and done, it would really require a contrived exercises through any of these three proofs to try to hold Campos de Pesé as under Italian management and control. All this is compounded by claimants' repeated misconduct throughout this case, which we have discussed in our written submissions and which we will briefly summarize today. Moving now to the issue of Mr. Pelas and Mr. Palacio and their witness statements and why they should be excluded. Very simply, Mr. Pelas provided 3 statements in this arbitration, Mr. Palacio provided 1. We count at least 80 instances in memorial, counter-memorial, and rejoinder in which claimant cited to or referred to or relied to the statements of Carlos Pelas. It is an understatement to say that they were heavily and extensively relying on Carlos Pelas to try to make this case. We, as Ms. Jaime indicated, we request that the tribunal exclude the statements of Carlos Pelas and of Ernesto Palacio. We submit to the tribunal that even with those statements on the record, their case was baseless. Without their statements on the record, their case is borderline frivolous. We have listed some examples of issues that claimant had portrayed as a big deal or as central in this case that are now left with zero evidentiary support in the absence of Pelas and Palacio. Number 1, the notion that Carlos Pelas was, quote unquote, calling the shots, directing, managing Campos de Pesé. That was purely based on Carlos Pelas's statements. There is no evidence, no documentary evidence in the record suggesting that Carlos Pelas was involved in any way in making the decisions of the business and operation and activities of Campos de Pesé. At most, what the record shows is that he was one of 5 or 7 directors, depending on the period of time, of Campos de Pesé. That's it. Number 2, claimant was advancing the notion that Carlos Pelas was the final beneficiary, it's their expression, beneficiario final, of around 20% of SER, and also, again, this is their language, that Carlos Pelas was the controlling shareholder of Campos de Pesé and or SER. The documents in the record do not show that he's either a final beneficiary or a controlling shareholder. That was purely based on expressions that he was making in his statements. Number 3, claimant was advancing the notion that the SER board of directors was getting involved in the operations and the activities of Campos de Pesé and making decisions. Zero documentary evidence in the record for that position. We need look no further than the actual minutes of the board of directors of SER. They do not reflect any decision of any consequence by SER regarding the business activities of Campos de Pesé. That was purely based on Carlos Pelas's statement, who is no longer here to testify. Number 4, Mr. Palacio, similar to Mr. Pelas, he was advancing the theory that he is the quote-unquote beneficiario final, again, his expression, of around 3% of SER. The records do not show him being a final beneficiary of anything. Therefore, that statement is left without any proof or evidence in the record. Last but not least, in the absence of their statements, there is no evidence of any genuine link or connection of any kind between them and the state of Italy, other than copies of their passports and consular certificates, which we argue are not enough. Let's move now to the issue of burden and standard of proof. On the issue of standard of proof, the parties largely agree that the balance of probabilities is the standard that should apply. Where the parties disagree is on the issue of burden. First point, we would say it is undisputed under the law that Campos de Pesé bears the burden of proving the elements of jurisdiction. What does that mean for this case? That Campos de Pesé had the burden of showing that this group is actually Italian for jurisdictional purposes, and that this group exercised directly or indirectly control and management over Campos de Pesé. We submit, claimant has failed to show both. We'd say to a certain degree acknowledging the evidentiary problem that they have and the fact that they have not shown either Italian nationality or control and management. They come up with the theory that there are two presumptions that should apply in this case and that shift the burden of proof to respondent. Presumption number one. Claimant argues that because they have provided passports of this group of individuals, then there is a presumption that they are Italian, and it falls on respondent the burden of showing that they are not. That simply cannot be, because respondent cannot be made to rebut facts that are solely and exclusively in the possession and control of claimant. Who knows whether these individuals ever met the requirements for Italian citizenship? Only claimants. How can that burden possibly shift to respondent? I'll just mention one example, which is, in our opinion, the most notable example of why this would be fundamentally unfair. It's the case of Consuelo Martinez Cuadra. She's one of the only ones in this group that purported to acquire Italian citizenship via matrimony. Italian law experts on both sides agree that to obtain Italian citizenship via matrimony, a person has to show a valid matrimony and knowledge of Italian language. They have provided zero evidence of both. All they did is provide a statement by Consuelo Martinez Cuadra without any supporting documents, no corroborating evidence, saying that she acquired via matrimony her Italian passport. How can that flip the burden to respondent to show that she wasn't married or didn't have a valid marriage or didn't know the Italian language? That is claimant's burden. But moreover, if the tribunal looks beyond the passports, as we submit tribunal should respectfully do, and looks at effective nationality, claimant also had the burden of proving effective nationality, and they have failed to discharge that burden. Second presumption. Campos de Pesé argues that because they have shown indirect majority ownership, which they have not, that there should then be a presumption of control and management that respondent needs to rebut. Ultimately, the support for this contention in claimant's papers is Caratube. They cite to Occidental, but in reading Occidental in detail, Occidental really only cites to Caratube for this proposition. And we submit to the tribunal that Caratube was not meant, and the way it is written and its facts didn't intend to create the general proposition for every future case. That if there is a showing of majority ownership, then there is a presumption of control and management. That is not what Caratube said, and that is not what Caratube intended to do in the way it was written and with the particular facts of that case. That makes the presumption fail at the legal level. At the factual level, again, it is undisputed that Campos de Pesé was not indirectly owned, at least as of August of 2014, in a majority by citizens of Italy. So this presumption simply cannot apply here. The issue of relevant dates, both parties largely agree that August of 2014 and May of 2020, respectively the date of the alleged breach, and the date of alleged consent are the dates that the tribunal should look at when deciding whether it has jurisdiction over this case. We submit to the tribunal in this hearing, as we've done in our written submissions, that the tribunal should also look at June 2011, the date of the alleged investment, just making a careful and comprehensive reading of at least Article 2 of the treaty. We also contend that claimant has, to a certain extent, conceded this point. One, because they agreed to produce documents from this period of time, the period of time of June 2011, and then second, because they repeatedly discuss it in their written submissions, and they repeatedly attempted to provide evidence regarding this period of time. Certainly, claimant would not have engaged in that discussion if they didn't concede, at least to some degree, the relevant of June 2011. I'm now going to turn it over to my colleague Tomás Solís for the issue of nationality.
Thank you, Mr. Pulesio. Good morning, Mr. President, members of the tribunal, Mr. Flores, colleagues on the other side, co-reporters and interpreters, have all good morning. It is an honor to be before you today to talk about the nationality of the claim before you. There are two independent legal reasons that, in our view, are dispositive of this case for lack of jurisdiction. The first are Mr. Pelas's and Grupo Pelas's representations made to the government of Panama even before they made their investment. Mr. Pelas and Grupo Pelas never disclosed to the government of Panama that they were Italian. As Ms. Jaime pointed out this morning, Mr. Pelas never used his passport to enter Panama until after the notice of arbitration was filed, and it could not be legally permissible for him to have never used his passport to enter Panama, but use it to now sue Panama under the Italy-Panama BIT. That is simply not allowed, and there are two decisions that are directly on point on this question. The first one is the Champion Trading v. Egypt, which found that the nationality relied upon by an investor vis-a-vis the host government is determinant on the question of nationality. And the second is the Fides Action Award that clearly stated that nobody shall abuse the right granted by treaties, and that the Nicaraguan nationals here are under an obligation to have dealt with Panama honestly and fairly, to represent their motives truthfully, and to refrain from taking unfair advantage. The second reason why this case could be or should be dismissed for lack of jurisdiction is that the Nicaraguans here are effectively and dominantly Nicaraguan, not Italian, and consequently they may not rely on their passports to claim Italian nationality against the government of Panama, to rely on the Italy-Panama BIT. And I'm going to go briefly into each of these two independent legal reasons that we respectfully submit are enough for this tribunal to dismiss this case for lack of jurisdiction. The first is the ICSID case between Champion Trading and Egypt. As we all know, and this case has been extensively discussed by the parties in our pleadings, this case related to 3 Egyptian nationals who had also American nationality. They sued the government of Egypt based on their American nationality, and the tribunal in that case rejected the claim. The claim was not rejected because of an application of the rule of dominant and effective nationality. The case was rejected because of the representations that the investors made to the government of Egypt when making the investment. And the tribunal said, and I just want to quote briefly, what is relevant for this tribunal is that the 3 individual claimants in the document setting up their investment use their Egyptian nationality without any mention of their U.S. nationality. That's exactly what Grupo Pelas and Mr. Pelas did in Panama. They invested as Nicaraguans, never as Italians. And the tribunal continued. The mere fact that this investment in Egypt by the 3 individual claimants was done by using, for whatever reason and purpose, exclusively their Egyptian nationality clearly qualifies them as dual nationals within the meaning of Article 25(2)(a). The relevant point of this case, for this case, is that the representations made by investors to the host governments have legal consequences. And the legal consequence in this case is that they represented themselves in Nicaraguan for almost 30 years. They never disclosed that they were Italian. And those representations, or the legal effect of those representations, is that they're bound by them. and they cannot now change that fact that they represented themselves consistently, exclusively, and invariably as Nicaraguans. The second case that I just mentioned before is the Finis Action Award. What the good faith considerations do not allow what the claimants are trying to do here. As we know, the theory of abuse of rights is not premised in the absence of a right. The right exists, but is being exercised abusively. That's what happened here. The tribunal, as I mentioned before, made clear that nobody shall abuse the right granted by treaties. So the question in this case, Mr. Pelas and the 25 rest of Nicaraguan individuals, they have Italian passports. But the question is, can they use those passports to sue the government of Panama under the Italy-Panama BIT? Our position is that good faith considerations do not allow the claimants or Grupo Pelas and Mr. Pelas to do that. It's not a good faith thing to do to represent themselves for years to a government as Nicaraguan investors, exploited that nationality, and then switch it just for purposes of bringing a case. That is simply not allowed. Let me talk briefly here about what is the task of an international tribunal on the question of nationality. And I think this is a critical point. First, the task of an international tribunal or of this tribunal is not to provide a all-purpose determination of a claimant's nationality. The task of this tribunal is to determine whether the claimant or the people behind the claimant here may rely on a nationality for purposes of bringing a case. For example, let's make three assumptions. Let's say that Mr. Pelas had decided to join us today, which he didn't. Let's assume that he used his Italian passport to travel from Nicaragua to the US to participate in this hearing. And let's assume that this tribunal finds that it lacks jurisdiction because he cannot rely on the passport. That would not mean that Mr. Pelas is not Italian. That would not mean that he cannot use his Italian passport to go back to Nicaragua. What that means is that he cannot rely on that passport to sue the government of Panama. And this is the main teaching of the Nottenbaum case, which, as we know, is the case that speaks about the rule of dominant and effective nationality. And let me quote a brief passage here. I'm not going to quote it, actually, in the interest of time. But basically what the court said was, when the court looks at a question of nationality, the task of the court, and I said before, is not to provide an all-purpose determination of nationality. And that's exactly what the case says. The purpose of the court, in this case, this tribunal, is to do two things. The first is to determine whether it is legally permissible for the Nicaraguan nationals here to rely on their passports to sue Panama. And two, whether that nationality, under the circumstances of this case, is opposable to Panama. That is the question that has to be answered before this tribunal. The question is not whether Mr. Pelas and all the Nicaraguan individuals here can use their passport to travel. The question is, can they use it to sue the government of Panama? And that's one of the approach that the court took. In the Nottenbaum case is the approach that we respectfully submit, is the approach that this tribunal has to take in looking at the question of nationality. It's not to provide a no-purpose determination, it's just to determine whether under the circumstances of this case, the Nicaraguan nationals can rely on their passports to sue Panama. We submit that they can't. Now, I want to talk briefly about the framework under the ICSID Convention that applies to the question of nationality. First, the ICSID Convention does not define nationality. In fact, the ICSID Convention has no provision with definitions. Unlike most multilateral treaties, the ICSID Convention simply doesn't have the definitions, much less a definition of nationality. Second, the Panama-Italy BIT does not define nationality. It defines investor, but not nationality. Therefore, there is simply no lex specialis before this tribunal on the question of nationality. In other words, this tribunal simply cannot interpret the term nationality in the ICSID Convention or the BIT because it's not there. There is no definition of nationality. In the absence of a treaty provision, as we all know, Article 38 of the Statute of the International Court of Justice gives us the sources of international law. First, you have treaties. Second, you have a custom. In the absence of a specific treaty provision defining nationality, it is open to this tribunal to have recourse to customary international law. In this case, the rule of dominant and effective nationality. As we know, under Article 31 of the Vienna Convention on the Law of Treaties, the general rule of treaty interpretation provides that as part of the treaty's context, the tribunal may look at any relevant rules of international law applicable in the relation between the parties. In this case, again, and I repeat, in the absence of a treaty provision, customary international law is legally allowed under the law of treaties for this tribunal to be applied. As I said before, and I refer here to the 1964 report by Dr. Brockes when they were preparing the convention, where he says and makes absolutely clear that nationality was intentionally left undefined. And again, I'm not going to quote here, but the reason why it was left undefined is they were discussing what was Article 10, Roman 10, which was a provision with definitions. One of the definitions that they were talking about was nationality. And the question of the rule of dominant and effective nationality was predominant in this discussion. However, things got complicated in the negotiations, and the decision was, let's simply drop. Let's not define nationality, and let's do two things. One, let's allow states to agree with investors on the questions of nationality. And second, let's let tribunals to make determinations of the question of nationality. With respect to the first point, as we all know, Article 27(2)(b) is the only exception in the ICSID Convention that allows a national of one state to sue his home state. And that exception is only legally permissible if there is an agreement between the home state and the investor to treat a locally incorporated company as a foreign investor. As Ms. Jaime noted today, it is, in this case, there cannot be an agreement to treat Campos de Pesé as Italian because it's legally impossible for a party to have agreed to something it didn't know. And the second point made here is it is for this tribunal to decide questions of nationality. And one rule that the tribunal has available to decide that question is the rule of dominant and effective nationality. That is clear from the history of the ICSID Convention. 8 years later, Dr. Brockes went to the Hague Academy of International Law and gave a lecture on the ICSID Convention in 1972. In that lecture, when he talked about Article 25(2)(b), or the second part of Article 25(2)(b) of the ICSID Convention, he said, the legal committee, talking about the legal committee drafting the ICSID Convention, abstained from defining nationality. And there was a general recognition that in the absence of ruling on their competence, tribunals might have to decide whether a nationality of convenience should be disregarded. And there is a footnote there, footnote 13, to the Nottenbaum case. That is the case where the rule of dominant and effective nationality was first articulated by the court. By the court, I mean the International Court of Justice. Therefore, there is no question that the history of the ICSID Convention does not exclude the rule of dominant and effective nationality. This is confirmed by Dr. Brockes 8 years later in this lecture, specifically making reference to the Nottenbaum case. And third, let me just briefly mention the case between SIAG and Egypt. That case incorrectly found that Article 25 of the ICSID Convention excludes the dominant and effective nationality rule. And it relied on the Champion Trading Tribunal to make that conclusion. And Mr. Schroyer says, the tribunal offered the conclusion that the regime established under Article 25 does not leave room for a test of dominant and effective nationality. That's what the tribunal in SIAG said. And Mr. Schroyer notes, strictly speaking, that conclusion went beyond what was necessary and is not directly supported by authority. including the Champion Trading Award. So there are 2 points here. One, the exit convention did not exclude the rule. Dr. Brockes tells us in 1972 that the rule is not excluded, it's actually expressly included or implicitly included. And third, Professor Shorey notes there is no authority for the proposition that the rule of dominant and effective nationality is excluded from the exit convention. It is not. And the Champion Trading Tribunal did not say that. They didn't even approach the rule. As I said before, the reason why that case ended up, the tribunal finding that it lacked jurisdiction was because of the representations that the investor made to the government when making the investment. That is why that case was found to be out of the jurisdiction of the center. Now, Article 1028 of CAFTA, and I just want to make reference to this just to make the point that the rule of dominant and effective nationality is an existing valid rule of customary international law. Evidence of that is included expressly in Article 1028 of CAFTA. CAFTA tribunals, like the tribunal in Avenby, Costa Rica, had made clear that the expression dominant and effective nationality in Article 1028 of CAFTA is intended to incorporate the customary international law rule of dominant and effective nationality, making reference to the Nottenbaum case. Under this rule of dominant and effective nationality, there are a list of factors that are relevant for the determination of whether a claimant is or is not a national of the nationality that he or she claims. One, habitual residence. That means place of birth, place where the majority of their life has been spent, place of residence. Second, individual personal attachment for a particular country. This includes personal and professional relationships. And three, the center of the person's economic, social, and family life. All these factors come directly from the jurisprudence on that rule under CAFTA. Let me talk briefly about how a claimant or an investor is supposed to prove nationality under cases falling under the Exit Convention. Now, the parties here agree that the passports and certificate of nationality on the record in this case are merely prima facie evidence of nationality. What we disagree on is what are the legal consequences of that principle. The claimant effectively argues that the passports are both prima facie and conclusive evidence of nationality. This is, of course, legally impossible. Something cannot be prima facie and conclusive at the same time. And the exit jurisprudence, it's clear, or the history of the Exit Convention, let me begin there. The same report I referred to earlier in 1964, Dr. Brockes says certificates of nationality are prima facie rather than conclusive proof, and it should be for this tribunal to determine whether the nationality of these individuals is Italian or Nicaraguan for purposes of this case. This comes straight from the history of the Exit Convention, prima facie evidence rather than conclusive proof for the tribunal's reference. Now, the committee in Soufraki, which is a case we all know well, specifically and expressly said certificates and passports, or in other words, international tribunals, exit tribunals, are not bound by certificates and passports in making a determination on a question of nationality. And I'm not gonna quote it because Dr. Pulecio is already impatient with me, so I will pick up my pace. But the point is that the passports it is well established that passports are only prima facie evidence of nationality. This principle, that passports are only prima facie evidence of nationality, rests on sound policy. A passport is a travel document that allows an individual to cross an international border by presenting it to an immigration officer. Relying on a passport to sue a foreign government on the basis of a treaty, it's quite a different thing to do with a passport. That is why, under the ICSID Convention, passport and certificates are only prima facie evidence, and it is for this tribunal to look beyond those passports and make sure that Mr. Pelas and the 25 individuals from Nicaragua are effectively and dominantly Italian for purposes of bringing this case. And the tribunal in Soufraki told us, the tribunal looked beyond Italian passports presented by Mr. Soufraki, 5 certificates of nationality submitted by Mr. Soufraki, and importantly, a letter from the Ministry of Foreign Affairs of Italy expressly confirming not only that Mr. Soufraki could claim Italian nationality, but that he could do so for purposes of bringing the case. The tribunal in Soufraki looked beyond that evidence and determined that Mr. Soufraki may not rely on his Italian nationality and dismissed the case for lack of jurisdiction. Now, Mr. Pelas and the rest of Nicaraguan nationals here are not dominantly and effectively Italian. Let me just look at Mr. Pelas as an example. The international law factors that are required for the determination of nationality are habitual residence, personal attachment for a particular country, and the center of a person's economic, social, and family life. And I will show you now the evidence of genuine links, allegedly genuine links, that Mr. Pelas is claiming support his argument here that he is a national of Italy. He was born in Granada, Nicaragua. He's a resident of Nicaragua, and he has never lived in Italy. So the first factor, under the international law rule of dominant and effective nationality, would not be met. Personal attachment for a particular country. Mr. Pelas applied for the Italian passport for the first time in 2007 when he was 54. We submit he's not particularly attached to Italy if he never had an Italian passport for 54 years. And the other elements that he uses is that he says, I understand Italian. He doesn't speak Italian. That's another way of saying that he understands Italian. That his children speak Italian and that his family travels to Italy. I think we would all agree that traveling to Italy or speaking Italian is not proof of Italian nationality. The Center for a Person's Economic and Social and Family Life, as Ms. Jaime demonstrated this morning, Forbes went to interview Mr. Pelas in Managua, not Italy. Why? Because that is his place of business. It's not in Italy. And let me talk about 3 other elements that I think are worth mentioning. One, he says that because he was nominated a honorary consul of Italy in Nicaragua, he's Italian. He also says that he was awarded the Order of the Star of Italian Solidarity, and because of it, he's also Italian. And he tells us that he sells rum that he makes in Nicaragua in Italy. I'm not going to talk about the last one because I think it's clear that making rum in one place and selling to another place is not basis for Italian nationality. But let me talk about the first point. The International Law Commission, the 2006 or 2011, commentary, the 1961 ILC commentary to the Vienna Convention on Consular Relations talks about the treatment that states give to honorary consuls. And there are 2 important things here. One, honorary consuls are normally nationals of the receiving state, in this case Nicaragua, not the sending state, in this case Italy. And second, a state may nominate a honorary consul that is not a national either from the sending state or the receiving state. Therefore, being appointed an honorary consul is not legally a evidence of somebody's nationality. Therefore, Mr. Pelas may not rely on his appointment as evidence of Italian nationality. Second, Mr. Pelas was awarded in 2008 this award of Italian Solidarity, and he was awarded it because he's an entrepreneur. You can see there it says entrepreneur, not Italian national. And importantly, the Ministry of Foreign Affairs tells us in the paper to the left that this award can be given to Italian nationals living abroad and foreigners. Therefore, a foreigner can receive this award and he would not be able to claim Italian nationality on the basis of having received it. For example, this order has been given to Mr. Stephen Sweeney from the United States. He's not Italian. I received the order in 2017. Mr. Shihab Ahmed Al-Fahim from the UAE. He's not Italian and received the award. And Mr. May Phuc Dong, he's from Vietnam and he's not Italian and he got the award. Therefore, Mr. Pela's appointment and the receipt of this award are certainly commendable, but only decorative for purposes of this case because they're not evidence on his alleged Italian nationality. And I just going to leave you here with the tribunal can review this in its own time. These are a list of the alleged connections the 25 individuals have claimed as basis for their Italian nationality. And again, I'm not going to go through all this. And I just want to make the Republic of Panama submissions. One, this case can be dismissed for lack of jurisdiction because of claimants' representations to the government of Panama that they were Nicaraguan and not Italian. And the tribunal can do so based on the Champion Trading Award and the Phoenix Action Award. Separately, this tribunal can also reject this case for lack of jurisdiction because Mr. Pelas and the 25 Italian nationals here are effectively and dominantly Nicaraguan and may not rely on their passports to sue the government of Panama on the bitterly Panama bid. Thank you for your attention, Mr. President, members of the tribunal. I'll ask that you please give the floor to Mr. Pulesio Boeg. Thank you.
Thank you. I will now move to the issue of control and management with three very concrete issues. Number one, the applicable legal standard, and then derived from that applicable legal standard, the two issues. Number one, lack of majority ownership. Number two, lack of indirect management and control. Regarding applicable legal standard, let's start with what is undisputed. Article 25 uses the word control. The Spanish version of the treaty uses the word controlada. The Italian version of the treaty uses the word gestita. This is the only treaty in which Italy used the word gestita as opposed to the word controllate. Gestita and controllate, according to the official Italian dictionary, mean by and large the same, with gestita entailing a more intimate level of involvement and direction. The meaning of gestita in Italian and of controlada in Spanish, the two terms in the treaties, again, mean by and large the same, with, again, the caveat that gestita entails a more intimate level of management and control. I think both parties agreed that controlada, the term in the Spanish version of the treaty, is more properly translated as controlled, and that gestita, the word in the Italian version of the treaty, is more properly translated to English as managed. Last but not least, Campos de Pesé repeatedly uses in its written submissions both terms, control and management, as both terms that Campos de Pesé must show and, according to them, purported to have shown. So certainly they have conceded that there needs to be a showing in this case of both Article 25 control and management under the treaty. Where does that leave us? We would say that that leaves the tribunal with the question of what meaning to give to the term control under Article 25 and what meaning to give to the terms gestita/controlada, let's use for short, management under the treaty. Claimant certainly doesn't offer a meaning for either of those terms, and just to be clear, because there was some allegation about this in rejoinder, respondent is not saying that there should be different interpretations of those terms depending on the nationality of the claimant or depending on the version of the treaty. That's not what we are saying. We are going to offer to the tribunal a proposed meaning, definition of the term control and of the term management under the treaty. We respectfully submit that control and management means both having a majority ownership interest and also actual direction of day-to-day activities of the local company. Why do we submit that to the tribunal? Largely based on 4 cases which both parties agree on and rely upon in their papers, but many others that have addressed this issue. Those cases are Caratube, Guardian Fiduciary, Standard Chartered, and United Utilities. What is the common denominator of these cases and all others that we have been able to identify in this space and that are cited in the parties' papers? The necessary starting point, the logical predicate of all tribunals that have analyzed the issue of control and management is, first of all, ownership interest. If there is no majority ownership interest, direct or indirect, there's not even a way to get to the question of control and management. That is what we see as the common denominator in all these cases. We have certainly not seen any case in which the tribunal reached the question of control and management based solely on the nationalities of the directors and officers of either claimant or claimant's direct and indirect parents, as the second and third proofs of claimant would attempt here. What I just said stands true with one exception, which is Thunderbird. Thunderbird, an NAFTA case, is unique. I think it's the only case that both parties have been able to identify where the tribunal found control and management of, in that case, Mexican entities by a foreign investor, despite that foreign investor was not the majority owner of the Mexican entities at issue. Depending on the time period in that case, the Thunderbird owned 30 to 40% of the Mexican entities at issue. But what is relevant about that case and what makes it unique is that the tribunal found essentially an alter ego relationship between Thunderbird and the Mexican entities at issue, meaning the tribunal found they were one and the same. Tribunal said Thunderbird is the one hiring vendors for the Mexican companies. It's the one engaging counsel for the Mexican operation. It's the one receiving legal advice with legally privileged material from the Mexican entities. It's the one communicating with the Mexican government. The employees, directors, and officers of Thunderbird are the same of the Mexican entities. An alter ego relationship that has nothing to do with the facts at issue in this case. This group of alleged Italians never even set foot in the Campos de Pesé operations. There cannot be an alter ego relationship and finding between this group of alleged Italians and Campos de Pesé, the claimant entity. Thunderbird is unique, and we'd say it's the exception that actually proves the rule. Where does that leave us for this case? That claimant had to show and has failed to show that Campos de Pesé was at any of the relevant times owned directly or indirectly by citizens of Italy, and that group of supposed Italian citizens exercised direction of the day-to-day activities of the operations of Campos de Pesé. With that, we move over to the discussion of those two issues. Issue number one, ownership. Issue number two, control and management. Regarding the issue of ownership, again, it is undisputed that this group of alleged Italians did not hold, at least as of August of 2014, indirectly a majority ownership interest over Campos de Pesé. Number two, it is undisputed that SER does not have a majority of Italian shareholders. Number three, the question that is disputed is whether SER is indirectly beneficially owned in a majority by individuals that happen to have an Italian passport. We'd say a largely irrelevant question, but now one that we will discuss and hopefully dispose of. Number one, Campos de Pesé is not indirectly owned in a majority by Italians. The tribunal might say, well, why are we here in the first place if that is so evident? Well, we're here in the first place because Memorial misrepresented this key fact to the tribunal. Memorial, in paragraphs 196 to 198, advanced the contention that SER had 51.2% Italian shareholders. We've now seen the registry of members of SER, and we know that that is false. But let's take that in steps. Claimant argued that SER had 51.2% of Italian shareholders, and that SER owned 100% of Panama Sugar Estates, and that Panama Sugar Estates owned 100% of Campos de Pesé. Thereby, claimant argued in Memorial, this group of Italians indirectly owns a majority ownership interest in Campos de Pesé. False. As we would learn months later, when we were able to review the actual shareholder records of the entire entity, as of August of 2014, SER owned only approximately 90% of Panama Sugar Estates. And because their supposed Italian majority was so small, 1.2% above the 50% threshold, then that made the indirect Italian ownership interest drop under 50% at the Campos de Pesé level. Number two, we have now seen the shareholder records of SER, and SER does not have a majority of Italian shareholders. In the best case scenario, 10 to 12% of SER shareholders are individuals who actually have an Italian passport. The remaining 88 to 90% of SER are either companies or individuals of other nationalities, not Italians. That leaves us with the final question, and it is, does this group of alleged Italians have indirectly a majority beneficial ownership interest over SER? We'd say they do not, because there are several of these individuals that claimant alleged were shareholders of SER that we can dispose of, such that they are not part of this group of supposed Italian beneficial ownership. Number one, Silvana Solórzano. Claimant argued initially in its papers, Silvana Solórzano is a shareholder of 1.2% of SER. False. We now know, after looking at her affidavit, Exhibit C-114, that she would only become a shareholder of SER years later, not in August of 2014. That's 1.2% right there. Let's move now to the Orlandi brothers. Claimant stated in its initial papers, the Orlandi brothers, the two Orlandi brothers, are shareholders of SER. They are not. We would now learn, with their papers in rejoinder, that the Orlandi brothers gave their shares in SER irrevocably to trusts of Guernsey, not Italy, in 2011. Irrevocably. The Orlandi brothers are not shareholders of SER. That's another 1% right there. Ernesto, if we subtract Pelas and the Orlandis and Renato Palacio and Ernesto Palacio and Silvana Solórzano, this group of alleged Italians, best case scenario, beneficially owns approximately 20 to 25% of SER, not majority ownership interest. That tribunal shouldn't even entertain on that record the issue of control and management, because the first prong of the applicable legal standard fails. Let's move now to the analysis of control and management, which we will do through the framework that claimant has offered, the supposed three proofs. Proof number one, claimant says this group of alleged Italians has the legal capacity to control SER. Well, let's stay with that statement for a second. They don't even try to argue legal capacity to control Campos de Pesé, which is the entity that actually matters. But further, Christopher Newton, their BVI law expert sitting here today, he conceded that this group of alleged Italians does not even have a shareholder agreement in place such that they vote in unison or as a block, thereby exercising some sort of collecting voting power. What legal capacity could they conceivably exert over SER? Let us look at the facts. Both experts on BVI law, Mr. Newton, Mr. Forte from our side, they agree that what matters in a BVI company are the shareholders of record, the actual entities or individual who own shares. This group of alleged Italians does not own the shares of SER. They have no legal capacity to vote and to act in SER. Both experts agree. Then claimant moves to the point of control in fact. Claimant argues, well, this group of alleged Italians can select the members of the board of directors of SER, and that means control. In fact, it doesn't, because again, both experts agree the people, the either individuals or entities that can actually vote in a shareholder meeting and elect a board of directors are the shareholders in the record, and this group of alleged Italians are not the shareholders in the record. They cannot and do not elect the board of directors of SER. Further, this group of alleged Italians has never had anything to do with the operations of Campos de Pesé. There is not a single minute of a meeting of SER shareholders where they discussed or made any decisions regarding Campos de Pesé. There is no direction of activities as the applicable legal standard would require. And moreover, the experts in Panamanian and BVI law do not dispute that the managers of entities in Panama and BVI owe no duties, no fiduciary duties of any kind to supposed ultimate indirect shareholders. So if the managers and directors of Campos de Pesé and the other entities at issue do not owe any duty to these individuals, how can these individuals exercise control and management? They simply cannot. Let's look a little bit beyond what's happening. If tribunal reads, as I'm sure they've done, this section of the rejoinder, the first proof of the rejoinder, what claimant is really saying, it's trying to pierce each of the entities that are non-Italians and that actually hold shares in SER, to try to say that because those entities may be beneficially owned by Italians, then there is Italian management and control. Let's put it differently. What claimant is really saying is that because this group allegedly is a final beneficiary of SER, then there is indirect management and control. We've already made the point that that is unprecedented, but let's focus on this issue, which is they have a statement in their rejoinder, which is that they've never argued final beneficiary status as the basis for control and management. Of course they have. Their own witness statements, C100 to C127, are the ones who put this fact at issue, because the witnesses refer to themselves as final beneficiaries. We didn't use that term. Their own witnesses use the term final beneficiaries to define themselves and to define their supposed relationship with SER and with Campos de Pesé. But let's go to what the BVI law and Panamanian law experts say. Everyone agrees. There is no place in the control and management and direction of either a Panamanian or a BVI company by supposed final beneficiaries. Mr. Mora, claimant's Panamanian law expert, could not have said it clearer or better. This is what he says in paragraphs 15 and 16 of his report. Beneficial owners do not have any right or power of control of their respective entity, either directly or through intermediary or third legal entities owned by the final beneficiary owner. Yes, we agree. That is the point. That is the point that they've conceded. There is no place directly or indirectly in the management or control or direction of a Panamanian entity such as Campos de Pesé by supposed indirect beneficial owners or final beneficiaries. Just one point, additional point, or final point in this issue of ultimate beneficial ownership. Understanding that claimant was putting this at issue by defining its own witnesses as final beneficiaries, we asked claimant, give us the disclosures that Panama Sugar Estates and Campos de Pesé have made to the Panamanian government regarding their ultimate beneficial owners, UBOs, which Panamanian law requires. And give us the UBO disclosure that SER has made to BVI authorities, as BVI law requires, of the UBOs of SER. Because if this case had any ounce of truth to it, what would we have seen in those UBO disclosures to the respective governments? The list of these supposed 26 alleged Italian individuals. They didn't give us anything. That's briefed in our written submissions. They didn't give us the UBO disclosures that we asked for. What appeared in the rejoinder? Exhibit C 203. Exhibit C 203 is a document prepared by Christopher Newton or members of his firm, the Maples law firm in the BVI, which purports to be a certificate as registered agent of SER, identifying who is the UBO of SER. Well, that document is telling, because the only UBO that appears in C203 is Carlos Pelas. None of the other supposed 26 Italians are there. Look at how BVI law defines UBOs. We have that. It says, any natural person who ultimately owns or controls a corporate and legal entity and includes, and then gives a list of examples. That's what the BVI statute says. Well, if there was any ounce of truth to the notion that this group of alleged Italians ultimately owns or controls SER, they would be in Maples records. They are not. The only person that was there is Carlos Pelas, who isn't here to testify about why he's there in the first place. I'll move now to the second proof. The second proof is SER's board of directors. I don't know if it's just me about the heat. Second proof is the board of directors. Claimant would put it very simply. They'd say, well, the majority of SER has individuals that happen to have an Italian passport. Let's start with that notion. The individuals that are sitting in the SER board, board of directors do not have any meaningful connections of any kind to Italy. I refer to Mr. Tommaso Lisa's part of the presentation. They are not effectively Italian. But the more broader point is there is no precedent for holding a purely local company such as Campos de Pesé as under indirect control and management of foreigners, because the directors and officers of indirect parents happen to have a foreign passport. Let's focus on three remaining points. Point number one, who are these individuals that had an Italian passport and sat in SER's board of directors as of at least two of the relevant times, 2014 and May 2020? By and large, these individuals did not have any direct or indirect ownership interest in SER. That means they were strangers to SER. If you remove those individuals with an Italian passport with no other connection to SER, with no ownership interest, direct or indirect, in SER, you are left, as of August of 2014, with just 3 of 11 members of the board of SER, which had an Italian passport and which had at least some connection of some kind with SER. As of May 2020, that's 4 of 11, only 4 of 11. In neither case, a majority. Let's move to the second point, and it is, if we want to know what the SER board was actually doing with respect to Campos de Pesé, let's look at the SER board of directors meeting minutes. There is not a single minute that discusses anything of consequence about Panama Sugar Estates or Campos de Pesé. There is no minute where the board is discussing, giving them direction, giving them instructions, giving them orders, making discussions or decisions about their business and activities. That's nowhere to be found in the board minutes. The only thing that we see in the board minutes of SER are discussions about having SER be the guarantor of obligations that Campos de Pesé is assuming. Being guarantor of an obligation does not mean exercising direction of control or business or activities of an indirect subsidiary. Acknowledging this fact, claimant tries to pepper their rejoinder with some statements that we would respectfully say are misleading, because they try to attribute to the SER board of directors a level of direction and control of Campos de Pesé that they were never exercising, unless this is some sort of unique company chaired by Mr. Pelas, who isn't here, that votes on issues and makes decisions that are never reflected in any way in its board minutes, unless this is that unique entity. There is no evidence that the SER board of directors ever discussed or decided on the issues that claimant provides in its rejoinder. We have some examples in our presentation, but we've brief written submissions on it and the tribunal can see it. The final point that we want to leave the tribunal with is that the actual minutes of SER's board do not reflect those issues that claimant argues the SER board of directors was deciding or discussing. The sole basis for those statements...
Mr. Palacio, I'm sorry, you have 10 minutes left.
Thank you. The sole basis for those statements was Carlos Pelas's affirmations in his declarations, which we respectfully submit should be excluded. But last but not least, we made this point in reply, and claimant doesn't even address it in rejoinder. If it is true that the tribunal should look at the nationalities of directors and officers in order to make a determination of foreign control and management, then by all means, let's look at the board of directors of the relevant entities to see if they had a majority of Italian nationals. Campos de Pesé never had a majority of Italian nationals. Panama Sugar Estates never had a majority of directors of Italian citizenship. Traverse PTC, the company above Traverse Atlantic Corp., never had a majority of Italian nationals in the board. And Theos and Essex, two entities that purport to own 2% of SER, never had a majority Italian board. So if we're going to look at the nationality of directors, then let's look at the nationality of directors of the entire structure, and the claim fails. Last but not least, in correspondence with us, claimant took the position that the nationalities of directors was irrelevant. How can they take that position with us in document production and then argue to this tribunal that that matters as a threshold for the finding of control and management? The third proof is Carlos Pelas is Italian. Again, it would be unprecedented to hold a purely local company as Italian under this basis, but let's take a look at what Carlos Pelas was actually doing in Campos de Pesé. He was never the chairman of Campos de Pesé. He was never the vice chairman of Campos de Pesé. He was never the secretary of the board of directors of Campos de Pesé. At most, he was one of 5 to 7 directors of Campos de Pesé, depending on the time period. He was never an employee of Campos de Pesé.
Sorry, counsel?
Yes.
Lift back your microphone a little, please.
Sorry. He was never an employee of Campos de Pesé. He was never representative of Campos de Pesé. He never had the authority to bind the company because he was never the legal representative. He never had a power of attorney of Campos de Pesé. But very importantly, Campos de Pesé did not even hold out Mr. Pelas as part of the management team of Campos de Pesé. Annex 4 to Exhibit C81, which we had to provide to the tribunal because claimant provided C81 incomplete without annexes. We went and found Annex 4 in the records of the government and provided it to the tribunal. And Annex 4 is a letter presentation by Campos de Pesé to the Panamanian government, identifying the members of its management team, the people that are going to be actually making decisions of Campos de Pesé. Carlos Pelas is not there. How can they argue control and management by Pelas when he was not even represented by Campos de Pesé to the Panamanian government as part of the management team? Let's look at this through the lens of vacuum salt. Vacuum salt is one of the few cases, perhaps the only one that the parties have identified as dealing with an individual shareholder that had a minority. Well, in vacuum salt, the individual at issue had 20% shareholding of the company. Carlos Pelas has nothing. But through the lens of vacuum salt, what vacuum salt said is, it doesn't matter if the business at issue is the brainchild of the individual. It doesn't matter if the business at issue of the individual was indispensable for the business at issue. What matters is whether the individual was in charge of the operation, making the critical decisions on important corporate matters. How can Pelas, who was never in the operations of Campos de Pesé, be deemed to have been making the critical decisions or be in charge? He simply cannot. Very quickly now to the witnesses that the tribunal is going to hear from. The tribunal is going to hear from our side, from Mark Forte, our BVI law expert, Isabel Kunzman, our expert who provides a calculation of the indirect ownership interest of the group of alleged Italians in Campos de Pesé. Her math is undisputed, as claimant concedes in rejoinder. We don't even know why they wanted to cross-examine here today. Robert Lindley, our expert on Cayman Island law, and Todd Flubacker, our expert on Delaware law. They are going to be focused on the trust structures at issue in Cayman Island and Delaware. We were initially going to cross-examine 5 witnesses. Now, without Pelas and Palacio, we are down to 3. Jaime Mora, their expert on Panamanian law. Henry Mander, their expert on Cayman Islands law. And Mark Alstrom, their expert on Delaware law. Those 2, again, focused on the Cayman Islands and Delaware law trust structures at issue. Last but not least, and again, we'll leave this with the tribunal, and it's been extensively discussed in our written submissions, claimant engaged in repeated instances of misconduct throughout this case regarding the representations that they made to the tribunal about the ownership structure, regarding the documents that were relevant for the parties to investigate and be able to argue this case, regarding who was the owner, and last but not least, the saga over the last month regarding Mr. Pelas and Mr. Palacio. We respectfully submit that those instances of misconduct are relevant, not only for costs, but because they deal and relate to the issue of control and management and information about control and management, which was either lacking or omitted, or which is now out of the record in the absence of Pelas and Palacio. We conclude this opening statement asking that the tribunal dismiss the claim in its entirety and grant the government of Panama's objections to jurisdiction. Thank you.
Thank you very much. We will now take a break for 15 minutes. We will resume at 10:45.
Hi, can you test the president's mic, please? Thank you.
This is a test of the president's microphone. This is a test of Eduardo's microphone. 1, 2, 3, 4. It is rather low. This is a test of the microphone. This is a test of the microphone. 1, 2, 3, 4. Is that better? Okay. Yeah, I'm going to go ahead and turn the gain up a little bit and just see if that gives us a little bit more volume.
Hey, Don, can you hear me? Hi, Hakim, can you hear me? All right. Hakim, can you hear me? Okay, great. Can you sit on the chair and speak like the president would speak? Okay, go ahead. All right. Let's do something else. Can we turn another mic on, please? Maybe Gonzalo, ask Gonzalo to turn his mic on.
Stand by. Okay, microphone check. 1, 2, 3, 4. Check 1, 2, 3, 4. Check 1, 2, 3, 4, 5.
Also an issue.
Yeah. Okay. Yes. So this is all.
Testing, testing.
Check 1, 2, 3, 4. Charles, I can hear you.
Sounds good. Testing, testing.
So we have two
We have
microphones.
two microphones talking at the same time.
Okay, check 1, 2, 3, 4. Microphone check. How is it, Charles? Check 1, 2, 3, 4.
This is Charlie Roberts in the interpreting booth. Can you hear me? I mean, I think it was okay. My colleague and I don't always, I thought it was okay and he was hearing an issue, but let's see. Testing, testing. Okay. And I don't know if you want to talk a little bit more. I mean, I think it's okay. Obviously, the ideal thing is one mic at a time, but for me, it's okay. I don't know if I think it's okay.
Okay, I'll just go ahead and wait so that way you want to test? Yes.
Hey, Kim. All right. Right. Yeah. Yeah, yeah, yeah. Okay, it's fine, I suppose. Yeah, yeah, yeah. That's fine. Let me try one thing. Oh, good idea. Good idea. Great idea. Yeah, just yeah. Okay, sure.
Okay, check 1, 2, 3, 4. We have 3 microphones open.
Right, right. Yeah, with the threes, it sounds roughly the same as it sounded with two mics. So, I mean, we're fine. The thing is, I don't know. There is always like a background sound, and that's the room, right, Hakim? Okay. Mm-hmm. Okay. I understand. I understand. Okay. Um, right. I think now the claimant will not use the podium. You can ask the representative is right there. But I think he's going to speak from the from. Okay. Thank you, Hakim. Thank you so much. Thank you.
Thank you for testing with us.
Yeah, no worries. Do you mind getting my screen back on, please?
Oh, yeah, sure, of course.
No worries.
You're not going to have any playback videos or anything like that?
No.
Yeah, you can turn on the microphone if you don't mind.
What, this one?
Yes.
Okay, we continue. We now give the floor to claimant for an hour and a half. As in the case of respondent, the secretary is going to alert you when you have 10 minutes left so that you can conclude in time. So you have the floor.
Thank you, Mr. President. Before I begin with the opening, I'd like to correct an omission I made in the designations of our delegation. Our paralegal Svetlana Stegny from Hughes Hubbard is here, and it just was not, I did not intend to skip her. She works very hard, and just wanted to acknowledge her presence here. Yes, sir. Is this better? Okay. I was probably speaking softly because I was embarrassed to have omitted a dear colleague when I introduced our delegation. Well, let's begin with the issue that these proceedings are about. It's a narrow issue. It's respondent's objection, jurisdiction, ratione personae to this tribunal's jurisdiction over claimant. The claimant is an investor under the BIT. So let's just start with the term investor under the BIT. And I've flown out Part 2B, which defines investor as a juridical person controlled directly or indirectly by nationals of one of the contracting parties. Now, there's a lot of moving back and forth today that we heard in respondent's opening between ownership and control. Let's always keep in mind what the treaty requires, that the investor be a juridical person controlled directly or indirectly by nationals of one of the contracting parties. What we are going to do today is walk through the documentary evidence that demonstrates that claimant was at all times between 2011 to 2020 controlled directly and indirectly by nationals of one of the contracting parties. The business decisions were controlled by 7 Italian members of the board of SIR, and I'm going to walk through evidence that shows how they controlled claimant through their control of SIR's Panamanian subsidiaries. And I was surprised to hear this morning respondent say that none of the SIR board meeting minutes discussed claimant's business, because the evidence shows otherwise. But what also surprised me is because in paragraph 109 of respondent's reply, respondent wrote, quote, based on the minutes of SIR's board of directors meetings that CP, that's claimant here, not Carlos Pellis, has provided in the course of this arbitration, it appears that the SIR's board did, in fact, discuss claimant's business, but that is of no consequence. They took the opposite position in this opening. And the presentation didn't get into the exhibits and documents that showed that, but we will today. You know, we also heard, and I'll address this now, a reference to Article 25 2A of the ICSID Convention concerning dual nationals. None of the Italian shareholders of SIR are nationals of Panama. The ICSID Convention prohibits a citizen of a state from bringing a claim against its own state. Article 25 2A does not prohibit dual nationality. What it prohibits is a dual national bringing a claim against its own state. So that's just not relevant. But let's get into the evidence. And before we do, I just wanted to put up the authentic treaty languages. And here we have controlada used in the Spanish version. I do not speak Spanish. I would infer that means control. I'll let those who speak Spanish judge for themselves. The Italian version uses the word gestita, and we heard in respondent's opening a good deal about that term. And respondent had an exhibit, and that exhibit was R13. And it defined gestita, or gestire. Gestita is, form of the verb gestire, and it defines it, and we've translated the definition into English. It's translated as manage, to administer property or interest on behalf of others, to have the management of them, a company, a hotel, a public establishment, an institution. In a figurative sense, and in recent usage, to conduct, regulate, direct autonomously according to one's will, one's life, one's affections, one's body, also a situation, having control over it. So, there's no doubt that what the treaty is focused on is control. The primary control that you're going to see was through the SUR board, at all times comprised of a majority of Italian nationals elected by shareholders who were also Italian nationals. And we will show shareholder meetings and show you that the quorum and the majority of people who voted were voting Italian shares. Let's not foreshadow too much. In this slide, it just shows that when respondent moved for bifurcation, they understood the issue was control. It's not ownership. What respondent's now doing is looking up beyond the SUR board and questioning how it is that some of the Italian shareholders way up the chain held their shares in SUR. And what you're going to see is whatever interpretation you give to these trust agreements, it did not impede the reality that 7 Italian nationals controlled SUR and SUR controlled claimant. And that is the issue in this arbitration. This is not an arbitration about Mr. Pellis. I will address his non-appearance and Dr. Palaccio's failure to appear at the conclusion of my presentation, because I think when the tribunal assesses the consequences of their decision, that decision needs to be made in context of this proceeding. And it was a bit stunning to me to hear that if you strike his witness statement, there's no evidence. We can't prove our case. I'll tell you at the end, you can strike it because what I'm going to show you doesn't rely on him at all. And you can see control. He's one of 7 of the directors. But there's a documentary record, contemporaneous documentary record, showing him making decisions with the other 6 Italian members of the board. So we'll get to that at the end. Little foreshadowing. So I wanted to just tell you how we decided to organize the presentation of the evidence. When the tribunal issued its procedural order number 2, it chose to bifurcate for one objection and said the other was intertwined with the merits. And the one objection is the one we're here about today. Is claimant an investor under the treaty? Does the tribunal have jurisdiction ratione personae? And in its recitation of respondent's argument, in paragraphs 9 through 16, the tribunal memorialized respondent's observation about the missing evidence. I'm going to go through each of those paragraphs and talk and show you how we filled what respondent pointed out was missing. So first, in the first paragraph, they said the claimant failed to support its claim that at the time of the investment in mid-2011, Campos de Pesé was indirectly majority owned by 26 Italian individuals who decided to invest in the bioethanol business. Here, when I get to this section, I'm going to show you a visual aid, a demonstrative of what is Appendix 5 to claimant's rejoinder. Appendix 1. Appendix 1 to claimant's rejoinder. and we show ownership at all relevant points in times. Now, there's a dispute between the parties that 2011 is even relevant. That date is when the decision to invest was made. A reference was made that we've accepted it as relevant. No, we just produced evidence to show that there were 7 Italian board members who controlled SUR and made that investment decision, which is what we're going to get into in part 2, where they said that we failed to show that the decision to invest in Campos de Pesé was driven by the Italian shareholders of SUR or by the 7 allegedly Italian members of SUR's board of directors. And I'll show you the evidence where those board of directors made that decision. And we'll see the evidence where it was subsequently ratified by SUR shareholders. And shareholders typically don't make business decisions on the ground. They have their rights under the applicable law. They elect a board. They have, under applicable law or any agreements, rights to do what they do, but there's some separation between the board and shareholders. Here, SUR board made the decision to invest. We're going to look at those documents. And then in procedure order number 2, paragraph 11, the tribunal memorialized how respondent submits that there's no reason to exist to believe that Italian nationals controlled, managed Campos de Pesé during the time it built or operated the bioethanol plant or at the time the dispute supposedly arose. In that section, we're going to go through and show you how SUR was intimately involved with that process. And there was a sort of brushing aside in respondents' opening of the significance of, they guaranteed some loans. These were not an insignificant amount of money that they guaranteed. At the end of this section, I'm going to show you that SUR undertook to pay debts held by claimant for which it was not a guarantor. After Panama repealed Law 42 and the bioethanol plant was no longer economical, the SUR board made a decision to return to producing sugarcane, and they assumed the debts of Campos de Pesé, the claimant, because otherwise a number of Panamanian banks would not have recovered their money. SUR wasn't under an obligation to do it, they just did it, and we're going to see that evidence. We get to 4, we cannot show that the investment was controlled or managed by Italian nationals. That'll be a very quick section. We'll show you more board minutes. In part 5, this memorialized respondent's objection that claimant had failed to provide evidence that any of the 26 alleged nationals ever had indirect ownership interest in Campos de Pesé. We will show you how you can trace that indirect interest. Part 6, there's no evidence that the Italian nationality of the 26 Italian passport holders was acquired in compliance with Italian law, and that if it ever was, they cannot be properly construed as Italian nationals. And we'll address some of what we heard today, that these aren't real Italians. It's a historical, it's a unique aspect of history that Italy and Nicaragua have a special tie. It's a bit of a historical anomaly, idiosyncrasy, if you will. And we're going to, earlier in this, we're going to go through some treaties between Nicaragua and Italy where Nicaragua commits to respect the Italian citizenship of people born in Nicaragua who descend from Italians. That was a sovereign prerogative of those two states to agree to respect that unique heritage. So this idea that these aren't real Italians, we'll get into it. Finally, paragraph 15 of PO2, the respondent, or the tribunal memorialized respondent's argument that there was no evidence that any of the 26 allegedly Italian shareholders have any real control or management over SUR Campos de Pesé. By this time, you'll see the evidence, and I'll turn to addressing the absence of the witnesses. So now, sorry. Why is it going? Yeah. If I may just take a sip of water. Part 1, evidence of ownership by SIR by Italian nationals. That's just paragraph 9 from procedural order number 2, explaining what we're addressing. This is paragraph 16 from appendix 1 to claimant's rejoinder. This summarizes the ownership stake by Italian nationals in 2011 as of June 1. And all through appendix 1, it lays out in substantial detail the documentary record of how they held it. And one of those documents is Respondents Exhibit 159, which is a Secretary of SIR's certificate listing the individuals Italian nationals who held shares in their own name, and some of the companies owned by Italian nationals. Now, with this document, you can't see how Italian nationals own those companies, but it does conclude by specifying the percentage of ownership on page 6, 50.89%. Here on the slide, we posted excerpts from the expert reports on Italian law. The passage at the top is from claimant's expert, Professor Luca Radicata di Bozzolo. And he says, the possession of an Italian passport is evidence of Italian citizenship. Italian passports are issued by the competent Italian authorities subject to verification of the existence of Italian nationality. The second box is an excerpt from Respondent's expert on Italian law. And he seems to agree. He says, the fact that these individuals hold Italian passports may indicate or provide prima facie evidence that the 26 individuals are Italian nationals. Claimant's expert filed a second report, and in paragraph 52, he said, Italian passports are issued by the competent authorities only to Italian citizens pursuant to Articles 14 and 16 of the law of November 21st, 1967, and subject to the verification of their Italian citizenship.
May I ask you a question? You don't make a difference between evidence of Italian citizenship in paragraph 40 of Clement, of Luca Radicati, and prima facie evidence? You don't make a difference?
My suspicion there is that because of the process through which one has to go to acquire it, which is in paragraph 52, and you have to prove, you can't just get an Italian passport without submitting proof. And there was tons of proof submitted. And respondent demanded in document request number 2 that we produce it. Some of these applications were provided to the consular office in Nicaragua going back to the 80s. We tried to obtain them. It's not entirely easy to get, who knows where they sit. We could not get the applications, but they were validly issued. So where this prima facie comes in, maybe that's the difference he makes. But we responded with an expert opinion saying, it's a little bit more than prima facie when you consider the process and the evidentiary requirements that must be met before these passports are issued. And Professor Carboni had an opportunity to respond. He did not. He did not submit another expert report with respondent's reply to respond to our expert. It's the process they went through and they got. We made serious good faith efforts to try to obtain the original applications. And I will say, none of these individuals acquired their Italian nationality after this case. Carlos Pellisin said 2007. Say the board members. And there are consular attestations in the record. You can go to Appendix 5, and you can look at all the documents, and they say, yeah, we affirm it. And let's just say it is prima facie evidence. What else? Why shouldn't we regard Italy's consular attestations? Why should we disregard them? Respondents suggested that we have the burden of proof that nothing untoward happened.
If I understand you correctly, you consider that prima facie evidence of nationality is sufficient?
Yes,
for the tribunal to have jurisdiction?
Yes, unless there is evidence that calls into question the legitimacy of that prima facie evidence. And in this case, there is none. Thank you. So I put up on the screen here, just as a reference, two old treaties. Treaty of Commerce and Navigation between Nicaragua and Italy, concluded in 1868, ratified in 1872. This is an exhibit to one of claimant's expert reports, expert on Nicaraguan law, and the Treaty of Friendship, Commerce, and Navigation, signed in 1906. It was Exhibit 2 to our Nicaraguan law expert reports. But the most interesting treaty was Exhibit 3 to our experts report, and it's the Convention on Citizenship between Nicaragua and Italy, concluded in 1917 and ratified in 1923. And you may recall that between those years, Benito Mussolini came to power. Now, what's relevant about this convention is we have Article 1 in Spanish, and I'm going to read from our memorial, paragraph 84. We say, Article 1 confirms and adopts the nationality provisions of the 1868 Treaty of Friendship, Commerce, and Navigation. An Italian citizen residing in Nicaragua preserve and convey their citizenship in accordance with their respective national laws. And Article 3 makes the application of the convention date back to 1868. In addition, the preamble of this treaty seeks to establish laws on the citizenship of the descendants who immigrate from Italy to Nicaragua. And then in Article 2, it provides that, quote, a child born in Nicaragua to an Italian father not born in Nicaragua, or if the father is not known, to an Italian mother not born in Nicaragua, is an Italian citizen. This is an international instrument, a treaty, ratified by Nicaragua and Italy. Those two sovereign states have a special historical connection. They memorialized that connection in a series of treaties, and it is not for Panama to question it. This is the cover of a book, that portions of which we put into evidence. And the title, the young man who left Italy to stay. And there's a number of stories. Mr. Pellis is one example, but there's a number of Italian citizens throughout Nicaragua. A lot of the members of the business community have Italian citizenship. There are old historical ties going back to the mid-19th century. It's a reality. So this is not a case in which somebody suddenly discovered, hey, let's do something cute and bring a claim under the Italy bit and make something up. There are long, deep historical ties that have been preserved. And the implication, there was an argument made that Mr. Pellis never presented himself to the president as an Italian. We had a legitimate expectation that we were dealing with a Nicaraguan. Well, claimant had a legitimate expectation that respondent wouldn't change Law 42 and ruin the economics of its investment. But Mr. Pellis wasn't anticipating, nor any of the others who attended that meeting with him were ever anticipating a treaty case. And when Panama repealed the law in 2014, in August 2014, the first thing they did was not to go start a treaty case. It's not an instance where you might have a claimant opportunistically looking to find its way out of a bad investment. This was a good investment. It was working. This is a case, claimant had a good investment, the law changed, and they didn't bring a treaty case. What they did was assume obligations of the investor, the claimant, the SIR board that controlled claimant, as we'll see in a moment, so that Panamanian banks would get repaid. Now, evidence that Italian nationals decided to invest in Panama. Here, just again, the reference to PO2 to which we're responding. And I'm now putting up the minutes of the annual meeting of shareholders on March 22nd, 2011, where the shareholders of SIR elect directors. And I've now shown the resolution here. Highlighted in green are the 7 Italians who comprise a majority of the board of SIR. And I'm now going to walk through their passports. CO2, you can find 26 more passports. There's a lot of passports. What did they resolve at this meeting? First, I'm highlighting who was there. The board members and the 7 Italians. So, yeah, these are board minutes of SIR. So the 7 Italians elected by the shareholders have a meeting on June 30th, 2011. This is Claimant's Exhibit 3. The 7 Italians are present. And they listen to a presentation by Mr. Ricardo Barrios about Law 42 of the Republic of Panama and how it established general guidelines for the national policy for promotion, advancement, and development of the production and use of biofuels. Sorry. And I just want to, let's look at the law. This is Law 42. And this is a law, established guidelines for national policy, promotion, advancement, and development of the production and use of biofuels and the generation of electricity made from biomass in the national territory. It was enacted for national agricultural production and productive employment, as well as to advance energy independence and promote local and foreign investment and the production of biofuels throughout the territory of the Republic is declared to be in the national interest. Now, we laid out in our memorial how provisions of this law were necessary to control price to make this an economical business, and those are what are later repealed. But this is the law that the SIR board, controlled by 7 Italian nationals, elected by the SIR shareholders, this is the law that inspires them to invest. So, and what they note is the national policy creates a stable market for production. The company and its subsidiaries have experience in the operation of sugar mills and bioethanol production. It could be in the interest of the company to invest through Panama Sugar Estates and its subsidiaries in a project for production of bioethanol in Panama. And the directors unanimously approved the following resolutions, and one of those resolutions is that through PSE, that's Panama Sugar Estates, and subsidiaries, that includes claimant Campos de Pesé, the company will undertake the investments necessary to develop the project.
Yeah, sorry to interrupt you again, but the law was referring to foreign and national companies. So how is your reasoning that it's a foreign company?
It's the definition of investor under the treaty allows for use of a domestic subsidiary.
No, I understand perfectly. But how does this document is an evidence that it's precisely the foreign company you mentioned?
I mean, it says on the previous...
Because, marketing and developing bioethanol or whatever, it's the law said to advance energy independence and promote local and foreign investment. So I miss a link in your reasoning.
I'd say the link is that nobody in Panama could do this. They needed the know-how from SUR. It promoted local investment because they poured a lot of money into the economy, building roads. They created 2,200 jobs. There were social programs. I mean, this is a real facility that did things. That was local investment. People took home money to their families.
Okay.
And the foreign investment is the money came from outside. The banks were not, the Panamanian banks were not going to loan Campos de Pesé the amounts that they loaned it if it was not controlled by SUR. I mean, it's SUR in the presence of that, lets the money be lent. And that, if you look at the law in later provisions, it provides for favorable lending terms for Panamanian banks. It's a stimulus measure.
Mm-hmm.
All right, and we're going to get into respondents' contention that there's no reason to exist to believe that Italian nationals controlled Campos de Pesé during the time it was built, that Campos de Pesé built or operated the bioethanol plant. And I put that, this was from Respondents' Memorial on Objections to Jurisdiction. They said SUR appears to be nothing more than an offshore shell with no employees or executive of its own. We're going to see SUR is very active. And what the gravamen of respondents' complaint at that time was, other than self-serving witness statements, no documents have been provided reflecting the appointment of SUR's board or its composition. We've provided them all, many of which have been marked as respondents' exhibits. But suddenly it's all about Mr. Pellis. But this case is about claimant. Mr. Pellis is one of 7 Italian nationals who was on the board of SUR who controlled the claimant. So what I'm looking at here are board minutes of SUR with respect to investment in Panama. And we've looked at those. There are further resolutions inspired by Law 42 that the company will undertake the investments necessary and provide capitalization, approve contributions of additional capital that may be required, and appoint Mr. Carlos Pellis, Adolfo McGregor, Bernard, and Ricardo Barrio without preference to carry out all acts necessary to comply with the subject matter approved herein. So that's what they approved on June 30, 2011. That same day, there is a shareholders agreement between, so this is the shareholders agreement dated 30 June 2001, and it concerns Panama Sugar Estates. And now, you'll recall that Panama Sugar Estates was owned 70% by SUR in 2011 and 30% by an entity called Group of Alcohols. And that entity with 30% had a different name earlier. What these two agree to here, and let me, is how they are going to govern Panama Sugar Estates together with their respective shareholding. And this is, the Exhibit C 132, and we've translated it in English, and you see it refers to the operating companies shall be governed by and shall comply with the resolutions of Panama Sugar Estates. The operating companies here refers to subsidiaries of Panama Sugar Estates, of which Campos de Pesé is one. And the other provisions of this document, it is an agreement between the two shareholders of PSE that SIR will be able to appoint 5 board members of PSE and the group of alcohols 2. And it says later in this agreement that the group of alcohols can appoint 2 as long as it has 15% shares. That's not on the screen. It's in other provisions. But you can look at that and find these in this document. By 2014, SIR acquired 90% of the shares in Panama Sugar Estates. By that time, SIR could appoint all 7 board members to Panama Sugar Estates. And eventually, SIR acquires 100%. But at all relevant times, by virtue of this agreement, SIR appoints a majority of the board of Panama Sugar Estates. It has control over Panama Sugar Estates. And there's a witness, Ricardo Barrio, testifies in paragraph 21 of his witness statement. The boards of directors of SIR, PSE, and subsidiaries were closely interrelated and were controlled by directors or officers of SIR, including Carlos Pellis, Adolfo McGregor, Tito Silva, Edwin Mendieta, and the undersigned. Respondent could have called Mr. Barrios as witness. Respondent did not. This is Exhibit R153. This is a respondent's exhibit. It's the minutes of the extraordinary general meeting of shareholders for Campos de Pesé on 20 October 2011. And it's on page 6 to 7. It lists the 7 board members who are appointed. Now remember, the agreement I just showed you gave SIR the power to appoint 5, the group of alcohols the power to appoint 2. These are the 7. You will see Carlos Pellis Chamorro is there. Edwin Mendieta Chamorro is there. And if you also look at Exhibit C 169, you'll see the membership of, who's on the board of Panama Sugar Estates. It's these same people. So, SIR controls Panama Sugar Estates, appoints 5 members to the board, group of alcohols appoints 2, and then the same individuals are on the board of claimant. That's how control flows from SIR to the claimant by Italian nationals. The 7 Italian nationals on the SIR board. This is sort of the before shot. This is what things looked like around October 2011 before the investment. It's from a draft plan for construction of the plant. Now come to minutes of the annual meeting of shareholders of SIR on April 17th, 2012. And they, and we saw how they elected directors. You can at the meeting. So you can dig into this. This Appendix 4 essentially summarizes the contents of Respondents Exhibit 17. Then on the 22nd of May 2012, and this is Claimant's Exhibit 142, and a counter memorial to jurisdiction, we have minutes of a SUR Board of Directors meeting. In green at the top, we have highlighted the 7 Italians who were present, and they resolved to authorize financing of a loan facility. That's a document. So that's an action by the SUR Board, which you heard this morning, they never did anything except loan agreements. We're going to see they did even more than loan agreements. Again, 24 July 2012, the 7 Italian nationals on the board of SUR approved another $4 million loan facility. Now, this is, I have on the screen paragraph 34 from Ricardo Barria's witness statement, and he describes a meeting with the president of Panama. And, this meeting didn't just take place in a vacuum. There was a lot of work that went into it. He describes it in the preceding paragraphs of his witness statement. There was a meeting with the Minister of Energy. Presentation was given there. That presentation's in the record. And I think, so the presentation to the Minister of Energy is C12, but I have on the screen here the presentation to the President of the Republic. And this is C15, page 5. You start to see some of the preparatory work that's been done. Showed you the before picture earlier. We're seeing what the money they approved has started to do. And this is from the presentation to the President, dated 10 September 2012. It's C15, slide 12 of that document. And it shows the total investment is going to be $210 million. And slide 13 of that presentation breaks down how that money is going to be used over time between 2012 and 2017. At the top, it says Fondos Inyectados a la Economía de Panama. I think that means funds injected into the economy of Panama. That's what they anticipated injecting through Campos de Pesé. Here we have the witness statement of Rafael Gonzalez, paragraph 45. He describes the construction and operation of Campos de Pesé's bioethanol plant. We were able to leverage the experience of Nicaragua Sugar Estates, a company organized and existing under the laws of the Republic of Nicaragua, a subsidiary of SUR, in the bioethanol industry. Many of our experts and advisors, for example, came from Nicaragua Sugar Estates Limited, operations subsidiaries of SUR, such as Walter Garcia, who supported the agricultural team of Campos de Pesé with the elaboration of the sugarcane planting plan. In addition, NSEL employees help provide training for Campos de Pesé's workers. This is where the know-how is coming in. It's not just money. Because Nicaragua, let me back up. It's Nicaragua Sugar Estates Limited and subsidiaries of SUR that are bringing in this know-how. And here on, paragraph 1, it's Claimant's Exhibit 197. It's an employment contract between, this is, I think, the former name of Group of Alcohols, and Rodrigo Gardinal, about his employment to work on this project. So they're bringing in outside talent. And Rodrigo Cardinal is the chief executive officer of Grupo Calesa. He formerly served as chief financial officer of Campos de Pesé, Panama Sugar Estates Corp., and subsidiaries. And I'm reading here from Claimant's Memorial on Jurisdiction and the Merits in the section Dramatis Personae. In those roles, he managed the financial accounts of Campos de Pesé and developed financial analyses regarding its bioethanol production. He also represented Campos de Pesé in meetings with government officials. Here we have witness testimony from Walter Garcia attesting to how his experience in the sugarcane harvesting process, I'll just read it. Due to my experience in the sugarcane harvesting process, in 2011, the board of directors of the Sur Holding Company, a company that controls NSEL's shareholding, that's Nicaragua Sugar Estates, asked me to evaluate the sugar mill owned by Campos de Pesé in Panama, an affiliate of NSLL, as both are subject to Sur's shareholding control. Specifically, I was asked to evaluate the sugarcane fields and determine the potential for production, growth, and agricultural yields. I inspected the quality of the land, the condition of the area, where the mill was operated, and the existing cane. I was never an employee of Campos de Pesé. However, at Sur's request, I participated in the decision-making process regarding the purchase of land, machinery, how to obtain raw materials, and the harvesting process at Campos de Pesé. Here, again, an example of Sur bringing in the knowledge and expertise of how to do this project, how to complete this project that the Panamanian government determined was a national priority. That was a matter of national security. Ricardo Barrios, in paragraph 38 of his witness statement, testifies that the project was financed through capital contributions from the shareholders of PSE, loans from affiliated companies, and financing granted by local banks and creditors, which validated the viability of the investment and the favorable environment for foreign investment that prevailed in Panama. This is footnote 206 from claimant's rejoinder. This lists all of the minutes of the Sur Board of Directors meetings at which the Sur Board, always with a majority of 7 Italian nationals, guaranteed loans to Campos de Pesé in these amounts. And these loans are from a variety of different banks. You can look at each of the minutes and see 5 of the banks lending these amounts were Panamanian banks. And that was, again, anticipated by Law 42 and the favorable credit facility that it set up. But Campos de Pesé is borrowing from those banks. Sur is guaranteeing these amounts. And here we just have a series of slides from presentation by Rafael Gonzalez to the Board of Directors of Panama Sugar Estates in October 2012. And I'm just going to walk through a series of slides here. The references are at the bottom. This is just to show you kind of how the work's going on. Rafael keeps reporting on a regular basis until the facility is built. And we're now on slide 90, Exhibit C28. Slide 70 of C28 is what is on slide 90 of this presentation. That's kind of the finished, those towers perform an important role. This is getting very close to complete and getting close to operational. Now we go back to the Sur shareholding company, minutes of the meeting of the members of the company, held on the 22nd day of April 2013. What I've got on the screen now are the minutes of the Sur Board of Directors meeting dated September 25th, 2012. And this is where they authorized pretty substantial financing. You see references to $15 million and $40 million. And here again, in green at the top, you see the directors present. The ones highlighted in green are the Italian nationals elected by the shareholders of Sur to serve as directors. This is minutes of a Sur Board of Directors meeting dated 24 September 2013. C-140. And again, here we have these 7 Italian nationals taking a role in the building of this program. And minutes of SIR shareholder meeting, 28 April 2014, C-193. Now, all right, we have minutes of the SIR Board of Directors meeting from November 25th, 2014. What happened between these two meetings? In August of 2014, Panama repealed Law 42. The project was no longer economical. The board meets, and you see the 7 Italian nationals are on the board to deal with this situation and address what to do. And that last sentence, when I first read it and somebody confirmed for me, it says that they're looking to mitigate the damages arising from the situation. Para reducir las pérdidas y perjuicios. And I apologize to every Spanish speaker in this room. I'm butchering your beautiful language. But know enough from Latin that that's what it looks like. Colleagues confirmed. That's what the board does. They say, how do we deal with the damage? How do we mitigate? Well, they mitigated in a couple ways. They reorganized the claimant to produce sugar, but one of the most significant forms of mitigation comes a few months later at a SIR Board of Directors meeting on the 24th of March 2015, in which, and this is C-158, again, all of the Italian board members are present, highlighted in green, and they resolved to take over loans. There are outstanding loans. Can we pull up C-158 just because it gets cut off here? Yeah, you kind of blow up the bottom there to say what I had, but what got cut off is sort of this prong one, mentioning these loans of 17.5 million, 15.5 million, and I'll go to the next page. And look at prong two, refers to $40 million and $34 million. So they're resolving to do something about that. And let's go back to the presentation, and I'll show you what they did and what was presented to them, to the board of SIR. This will be slide 101. They approve essentially a refinancing, a loan facility. So that those other loans, SIR was not obligated, was not already a guarantor. And those were Panamanian banks who were going to be left on the hook. And SIR was under no obligation to do this, but it essentially refinanced and took on a 10-year obligation to repay those amounts. SIR is still repaying loans made by Panamanian banks to Campos de Pesé, the claimant. And respondent mentions legitimate expectations about Italian nationality. And respondent casts aspersions about Mr. Carlos Pellis's character. Don't want to engage in that, but members of the tribunal, I suggest that if this is evidence of his character. He and the other Italian members of the board were under no obligation to do this, and they ensured that there was no fallout to the Panamanian banks as a result of Panama's sudden reversal of its policy. It was an honorable decision, and one that prevented further injury to others, to Panamanians. All right, let's move forward. All right. minutes, we're now at the minutes of the shareholder meeting of 30 April 2015. Let's go. All right. I'm going to go very fast through the rest because that's the documentary evidence of control by Italian nationals. And Appendix 5 shows you where you find all of the evidence of their Italian nationality. And I showed you Appendix 1 and the visual aid and how you can see the ownership. But the fundamental part of control is the 7 Italian nationals in control of SUR and how they controlled Panama Sugar Estates through their agreement with Group of Alcohols, which they eventually managed to just get 100% of Panama Sugar Estates, and appointed the same board on claimant. SUR controlled claimant. SUR was controlled by Italian nationals. SUR's board consisted of 7 Italian nationals elected by Italian nationals who voted their shares. Failed to provide evidence that any of the 26 Italian nationals ever had an indirect interest. Let's just go forward. What we've done here is just point you to Respondents Exhibits 161 and 162. This is evidence of Panama Sugar Estates ownership of claimant. On slide 111, we point you to Respondents Exhibit 14 and Respondents Exhibit 16 showing evidence of SUR's ownership of Panama Sugar Estates. Next slide. And this is evidence of Italian ownership of SUR. We talked about that. Its claimants were joined to Appendix 1. The demonstrative aid I walked you through to visualize Appendix 1 uses a visual aid to navigate it. That C204-1 is in PDF form. C204-2 is the interactive form that I used. And you can click and watch everything, how it changes. And all the documentation of those changes is in Appendix 1 to our rejoinder. Next. Here. Okay, go ahead. This is Appendix 5 I mentioned. Just scroll through this. This is where you find references to Italian, all the evidence in the record of the Italian citizenship and what we have in terms of consular declarations, consular attestations, passports, everything. Dates and references and, it's all there. It's one-stop shopping. I just reproduced it here. Hope that the slide deck would be useful. Next. All right. Finally, go ahead. The last objection was, some calculations about shares, and it renders it implausible that they have any real control or management over SUR Campos de Pesé. I've just shown you that in the evidence in Part 3. Go forward. As to Mr. Pellis, respondent claims that his involvement in Campos de Pesé's business in Panama was limited to a single meeting with former President Ricardo Martinelli on 10 September 2012 and a purported discussion about a possible bioethanol plant in Panama, which does not constitute Italian control over Campos de Pesé. The documentary evidence is overwhelming that Carlos de Pellis was one of 7 Italian nationals in control of SUR, and they were deeply involved. And we showed you the control. And a representation was made that no one else ever went to Panama. That's not true. I think it's 2C to the board. The members of the board of SUR attended the board meetings of Panama Sugar Estates. And the board meetings of Panama Sugar Estates were held in Panama. And that is in our memorial. It's Appendix 2C in our memorial. Claimant's counter memorial on jurisdiction, Appendix 2C. You can see the SUR board coming to Panama to meet with Panama Sugar, to attend Panama Sugar Estate board meetings. So this fiction that Carlos Pellas just walked in, met with the president once, it's just not supported by the record. And no one just walks in to see the president, and the witness statement I referred to earlier talks about the preparatory work that leads up to that meeting, and a meeting with the Minister of Energy, and I referred to a separate presentation to him, and that's in the record. So a lot went into this investment. Panama Sugars, the claimant still exists today. It's making sugar cane. And Sir is still today paying the debts from the investment that was destroyed by the repeal of the law. And respondent asked this tribunal to find that these were not real Italian nationals, that this was brought in bad faith. The one sincere thing I heard is that perhaps Panama didn't know they were Italian nationals, but there's no requirement that Panama knew they were Italian nationals. They are, but it's a fact. That's what the treaty requires. And it is a product of a long historical tradition of ties between Nicaragua and Italy that those two countries have enshrined in treaties between themselves to respect. And these are Italian nationals in control of claimant. Claimant is an investor. Everything above the surboard about trusts is a red herring. You can agree with respondent, you can agree with us and our experts. It doesn't change the factual reality of what happened. So why did we put in experts to respond to something we felt is irrelevant? Prudence. Experiences taught you just don't leave expert testimony unaddressed, but those trusts have nothing to do with this case. And the Orlandi Trust, I showed you the footnote, or referred to the footnote in the memorial that talked about them, yet there were no document requests about them. So this comes now, I've come to the point. At the beginning I told you I would answer the question that you directed me to answer: what consequences should you draw from Mr. Pellas's absence and Dr. Palazzio's absence? And I said, you have to assess the consequences in context. They had nothing relevant to offer. The trusts don't matter. But even if you were to disagree with that, you'll hear from at least our expert on Delaware law that a Delaware court interpreting a trust instrument will not accept oral testimony from a grantor as to its meaning. It's kind of logical, because otherwise every grantor who regretted his decision could hire some lawyers, create an ambiguity, and come in and resolve it. It's a rule once. But these are also revocable trusts, as our expert says. But in the end, none of it matters. And we told you in a letter on March 22nd, respondent made an application to throw the trusts out. And we said, you could. And you could decide the case on the papers. Because they don't amount to a hill of beans. For the one narrow issue in this case, was claimant controlled by Italian nationals? I've showed you it was with evidence, a lot of which was respondent's evidence. Referred to a lot of our exhibits in doing so. So what consequences? We submit the tribunal may strike both witness statements for purposes of this jurisdictional hearing if it finds that remedy to be just. The tribunal may also afford them whatever weight it feels appropriate. But the tribunal may have noted that this presentation, claimant, did not rely at all on the witness statement of Mr. Carlos Pellas to prove any of what it needed. Now, he featured in the narrative because he was one of 7 Italian board members, but that's a documentary record. And I will submit that whatever consequences follow, if they want adverse inferences can't contradict reality. The purpose isn't punitive. And I very much appreciate that the tribunal did not share Mr. Pellis's assessment of risk. And I want to assure this tribunal that counsel discharged our obligation in the procedural order as best we could to ensure his presence. He made a risk assessment, and everybody has to assess it for themselves. But people also assess risk against benefits. You know, someone might go somewhere dangerous if their child was there, but maybe weren't willing. He assesses risks. His testimony has no bearing on the construction of the trusts. And the trusts, however they're construed, have no bearing on the factual reality that Sir controlled claimant and is still paying the debts it incurred from its investment. So that's the reality. He didn't come, and so we are in your hands and at your mercy. And make whatever decision you think is just. But if you question for a moment his integrity, remember what the Sir Board did when the Panamanian banks were left holding the bag as a result of Panama's change of regulation, because that speaks directly to his character and what type of man he is. He's an honorable man, and this concludes claimant's opening statement.
Thanks very much.
Sorry, it's air conditioning. I have a question. Well, I would have many, but I will concentrate on maybe one question which I will, in a way, ask both parties to answer. From what I understood from the file is that Mr. Pellas presents himself at times as Nicaraguan, Italian, or Spanish. And the representative of the government indicated us, mentioned R0005, where Mr. Pellas says that his nationality is Española. So then I also understand that the report, in the first report of Professor Radicati di Brosolo, paragraph 41, he says, the conclusion that the Italian shareholders hold Italian nationality is not affected by the fact that some of them may hold a different nationality, and especially the nationality of one or more of Mexico, Nicaragua, Costa Rica, United States, and Spain. Then I would like us to look at R0010. Can we go to R0010? I open it, sorry, I have to. Respondent, exhibit. Okay. Yeah, so apparently we see that Carlos Francisco Pellas has several nationalities, but the others also. Then my question will concern the application. Well, you mentioned the history. You mentioned the history and the different treaties. And I take your slide 45, where you explain un ciudadano italiano residente in Nicaragua y un ciudadano nicaragüense residente en Italia conservan y transmiten la propia ciudadanía según las respectivas leyes nacionales. That means that an Italian will still be Italian according to the Italian laws. And in the respondent reply, in paragraph 114, it is mentioned that Campos de Pesé Italian law expert agrees that an Italian who emigrated from Italy prior to 1992 would have lost his or her nationality if he or she voluntarily obtained another nationality. This is especially important regarding Mr. Pelas and three of his relatives with Spanish nationality, Eduardo Pelas, Silvio Pelas, Felipe Mantica. It explains that they don't live in Spain and therefore they have voluntarily acquired Spanish nationality. So my question is when and what consequence? Because if they voluntarily, or if their ancestors voluntarily acquired Spanish nationality, normally, according según las respectivas leyes nacionales, they lost their Italian nationality. So I would be happy to be clear on that, because I think it's very difficult to understand and very important for the case.
I think it comes down to the word voluntary. It requires an act of volition. And under Spanish law, Spanish citizenship is passed from parent to child as a matter of birthright. And this is paragraph 233 of claimant's rejoinder. And we're citing the Spanish Civil Code.
That as Italians, they acquired Spanish nationality. They did not acquire it by birth. If I understand
He did not voluntarily. I mean, the experts agreed that the voluntary acquisition of citizenship, so in this Soufraki, the person acquired voluntarily Canadian citizenship. He went and applied and made an application, and that rebutted the prima facie evidence of his passport. In this case, one line of his family was Spanish, another was Italian, and by operation of those states' laws, he possesses those citizenship. It is not something he went out and sought. He did not move to Spain and say, I want to become a Spanish citizen. He possessed it. Much like he possessed Italian nationality under Italian law. He filed the documentation that was necessary, and it was recognized because it was birthright recognition. And without that voluntary act, that provision of Italian law does not apply. Mm-hmm. And I would also say the evidence confirms our interpretation, because authorities would not otherwise confirm that he is an Italian national repeatedly and issue passports.
But in all the charts I have seen no Spanish or American or whatever ancestors.
I'm sorry.
In the different charts, you propose different charts, family story, etc. But I haven't seen, because your own expert says that they might have Mexico, Nicaragua, Costa Rica, United States, Spain, and in the different chart, I didn't see ancestors of this nationality that could be, transmitted. But maybe there is. I mean, I'm just trying to understand the record.
Yeah. I'll give you the record reference in just a second. And the place where you can see this is Exhibit A to the second witness statement of Mr. Carlos Pelas. So I am now.
So it's.
It is again? It's Exhibit A, which is the family tree of the Pelas family. So yeah. So if this is on your mind.
But you have presented a family tree on page 30 or 31. No, that's my page. Sorry. I don't remember. I have here a share ownership, a family tree of Pelas, and I see no Spanish here. So maybe you forgot, or I don't know. Because we have Managua. I mean, the only one that was born in Italy is Francesco Alfredo Romano Pelas Canessa, born in 1850. And then from all this, you consider that they are Italian, and I agree that this might be not voluntary, but for the rest?
Yeah. We'll put the Pelas family tree up on the screen, and can you sort of accentuate that box? Yes. No, back up. So, yeah, right there. My colleagues are informing me that this is where the Spanish line comes in. Carmen, Amelia, Teresa, Chamorro, Bernard.
And the woman transmits her nationality?
Excuse me?
I mean, what does, but what does the Italian law say on that?
Well, it says, you know, what you pointed to is voluntary. And again, I emphasize that a person who inherits a nationality from their parents did not voluntarily acquire it. They committed no act of volition like the claimant in Soufraki. And I recall the quote from Aaron Broche, distinguished between the involuntary acquisition of citizenship and the voluntary acquisition, was one of respondents' legal authorities, quoting Broche. There was some concern that he was talking about how the rule of dominant and effective nationality should apply, and Broche mentioned that we got to think about where nationalities, there's a distinction between involuntary and voluntary acquisition. The passage you pointed me to on your question under Italian law refers to voluntary. He inherited from his mother. The passage of nationality in Spain to parent or child is claimant's legal authority C-156. That's where it's laid out. That's how he got it. And you know, some people have many nationalities, and they represent themselves as such at various times in various different contexts, and that's not necessarily wrong. In Respondents Exhibit 10, it looks more like a demonstrative exhibit to me than a factual exhibit, where they're saying, here's all his various nationalities. Okay, nobody denies that. He inherited a Spanish line from one direction and Italian from another. He has not committed any voluntary act within the meaning of Italian law that would cause him to lose citizenship. You know, our expert affirms his citizenship. The Italian consulate affirms his citizenship. Respondent's Italian law expert had a chance to rebut our expert and chose not to. There's no voluntary act. He was born.
Maybe the respondent could also comment.
Madam Arbitrator, thank you very much for that question. And if I may, I'll start with Soufraki. Your question is very relevant and very important for Soufraki, because Soufraki actually analyzed a very similar fact pattern, where there was a supposed Italian that had voluntarily acquired Canadian citizenship. He wasn't born in Canada. He went out to Canada and sought out the nationality of Italy, causing him to lose Italian citizenship. And one of the issues that was important in Soufraki was precisely that individual had never disclosed to the Italian authorities the fact that he had voluntarily sought out Canadian citizenship, such that the Italian authorities never had any idea about whether there was a loss or not of nationality. Identical to the facts at issue here. Madam Arbitrator is correct. There is not a single document where Pelas identifies himself as anywhere other than from Nicaragua. Indeed, for example, just to name an example, all of the documents in the trust structure refer persistently to Mr. Pelas as of Managua or of Nicaragua. But focusing specifically on the issue of Spain, Madam Arbitrator is correct as well. There isn't any evidence on the record that any of these individuals, all the way up to 850 in their family tree, was born in Spain or ever lived in Spain, or that there is any basis for them to have acquired Spanish citizenship, other than they voluntarily went to Spanish authorities whenever they wanted to have a Spanish passport and got that passport. There is no evidence that any of them, including Carlos Pelas, ever showed that Spanish citizenship to Italian authorities, such that Italian authorities could assess whether there had been a loss or a forfeit of nationality. And that is a question that is very relevant, and it is also relevant and connected to one of the issues we discussed in our presentation, which is the burden of proof. This is exactly one of the issues where simply providing a passport or a consular certificate cannot be made to create a presumption of nationality, let alone invert the burden of proof to respondent. Because how can we know anything about their supposed Spaniard lineage or what impact that had on Italian authorities if they haven't produced any evidence of either the lineage or any disclosures or discussions about that issue to Italian authorities? So we of course agree with Madam Arbitrator, and we think it is a very relevant issue of which there has been no evidence provided that supports that they did not forfeit and lose their Italian citizenship.
Some other questions. The respondent counsel mentioned when in his presentation Notenbaum, especially, and the effective and dominant nationality. I understood from you that you consider this is not relevant here?
Yes, Professor Stern, it's not in the bit, although I believe it is in the CAFTA makes a reference to
But the
dominant.
bit says nothing, so I mean a bit should be interpreted with reference to public international law, which I'm a little bit familiar with, and so what is your argument not to accept the idea that in the presence of two nationalities, the effective and dominant nationality should prevail?
That it improperly invades on the sovereign prerogatives of Nicaragua and Italy to recognize their unique historical relationship and citizenship. That dominant and effective, if the bit had, if you're going to apply customary international law principle, then you need to look at, you really need to focus on Nicaragua and Italy's relationship and how the significance they attached, and I think that would factor into that analysis, that Nicaragua's commitment to Italy to recognize all Italians' ability to transfer a citizenship by birth, it features in. It's not, they live there, they speak the language,
okay.
But I think it matters.
Okay, so let's, I understood you that you don't apply effective and dominant nationality, but if the tribunal were to apply it, do you consider Carlos Pelas an effective and dominant Italian national? I understood that he doesn't speak Italian. Is that correct? I mean, he's not here to tell us. I couldn't speak with him in Italian either, but...
I think he speaks it better than I speak French.
I don't know how much you speak French. I'm sorry. Maybe we can try.
Parler français?
Alors, the end of your answer in French, please.
Ja, ich kann es auch auf Deutsch machen, wenn es Ihnen lieber ist. Okay, dann machen wir es so. Sorry. I would say, well, one, he's not here, and I can't make representations of fact that would be in the record. I spoke to him. I think respondent's characterization of his ability was mostly fair, although a bit exaggerated. He understands it very well. He can speak it affirmatively. I think there's a little hesitation because it's not his most comfortable language. But, he was honorary consul. The president recognized him with the award. Again, that doesn't necessarily confer citizenship on him, but it has something to... The president of Italy does not just confer awards around the world on successful businessmen. The president of Italy conferred that award on a Mr. Carlos Pelas of Italian heritage in Nicaragua. And so his Italian nationality was a factor in that decision. And what is dominant and effective in one case situation, it has to be evaluated contextually. And I would say, yes, he is. But it depends on the context in which you're applying it. And that brings us back to the bid. If the bid had said controlled by Italian nationals, dominant and effective nationality, he is Italian or something, get into the analysis, and some of the facts might be different. But if you're going to apply it as a matter of overarching customary international law, I think you have to take a very broad view of what's dominant and effective. And the purpose, if applied not as a treaty term but as a principle, is to ferret out opportunistic invocations of nationality that don't have, have maybe a technical basis. But this isn't opportunistic. None of the shareholders required, none of this was done for purposes of this arbitration. There's a lot of Italians involved in this investment. We've shown you the, and if you're going to apply the customary international law principle of dominant and effective nationality to ignore that reality, it ignores, to some extent, the reality of the relationship between Nicaragua and Italy as they enshrined it in their treaties. And as Panama pointed out recently, its correspondence, it's not something the tribunal should do.
Well, it's a shame he is not here, because we could have asked why he asked his passport in 2007. Maybe because Ortega was inaugurated as president? Can that have a relationship? In 2007, if I'm not mistaken, on historical facts? Well, but he's not here, so
I'm sorry,
let's
I had a bad infection in my ear and I've lost hearing in part of it. So
I retire this question. I cancel my question. It's just in my mind. Just one last point, maybe. If we look at respondents' reply, paragraph 50, can we just maybe show it? It's the shareholder composition of SER. So share percentage held by BVI companies 30.6%, shares percentage, maybe I don't read it, you have it on you, or you can show it on the screen, or I can read it.
Yeah, no, my colleague here is going to, this is paragraph 50 of respondents'
reply, yeah.
Okay.
I just wanted to know.
Okay.
All
right, yeah, so blow up paragraph 50.
So shareholder percentage owned by BVI company 30.6, share percentage owned by Panamanian company 8.06, share percentage owned by Nicaraguan company 0.36, etc., etc. And the share percentage owned by trust of unidentified nationality 1%, share percentage owned by alleged Italian national 10.71%, share percentage owned by individual or company of other nationality 49.36%. My question is whether you disagree with this factual presentation, and if you disagree, where do you disagree?
There's a lot of numbers and calculations.
Yeah, maybe you can answer at a later time, because I understand that it might be a little bit complicated.
Yeah. May I give you a sort of macro level answer right now?
Macro level, I agree.
If you go to the SIR shareholders meetings and you look at who voted, so there's some Panamanian companies. What this paragraph is doing is it's myopically focusing on an intermediate level to say, hey, these are Panamanian, these are that, and it's not going up to the top to see the Italians. But if you actually look at the shareholder meetings and who shows up for some of these companies, it's Italians. And one of those is Respondents Exhibit 17.
Okay. Thank you. Maybe I have bothered you enough.
It's always a pleasure, Professor Stern.
I have two questions before we break. The first relates to the relevance or irrelevance of the participation of Italians or alleged Italians in the board. And particularly, respondent has made a point here, and I would like to hear both parties on that, to the effect that the members of the board who have Italian nationality but have no interest whatsoever in the company should not be considered Italian nationals for purposes of our jurisdiction. So I would like to hear claimant and respondent on that.
Thank you, Mr. President. I see no principled basis to distinguish between Italian nationals on the board controlling the investor based simply on those that held shares and those that did not. But this is where perhaps the relevance of the Italian shareholders come in, because the Italian shareholders voted to confer powers on these seven Italian nationals, and those 7 Italian nationals, whether they held shares themselves or not, exercised and performed the duties conferred to them upon the shareholders. And we've shown you who showed up to vote, and that's sort of how the authority flows from the shareholders to the board, all the way down to the investor. And I think there's no reason to just treat those Italian SIR board members any differently, because they were empowered and they were Italian nationals and they exercised control together with the other Italian nationals.
Thank you. Respondent.
Mr. President, thank you. 5 very concrete points, and I know Mr. Solis also wants to make a final point in that regard. Point number 1, there's no precedent for this notion that directors of an indirect parent can create the requisite indirect foreign control or management. Number 2, those individuals sitting in the SIR board that happen to have an Italian passport, no effective connection or genuine links of any kind with Italy. Some of them didn't even provide affidavits to this tribunal, and the ones that did, some of them, for example, never even traveled to Italy, which is one of the supposed connections that they try to argue for some of the Italians. Number 3, correct. The majority of those Italians that happen to have a passport and sat on the board did not have an ownership interest, direct or indirect. Now, whether there's a legal principle or not, well, it's kind of common sense that if they are strangers to an entity and are simply placed there because they have a passport, that cannot create the requisite indirect foreign management and control under international law. Number 4, if we, as we mentioned in our presentation, if we are to look at the passports that directors in the different entities in this structure held, then that would make the analysis fail at the threshold. Campos de Pesé didn't have a majority board of Italian members. 1 member of Campos de Pesé's board was Italian, Pelas. The other 5 or 6 or 7, depending on the period of time, non-Italians. Panama Sugar Estates, 1 member of the board had an Italian passport, Pelas. All the others, 5, 6, or 7, depending on the period of time, not an Italian passport. And entities above SIR, likewise. We mentioned just 3 examples, Travers, PTC, Enfeos, and Essex, not a majority Italian board. Last but not least, before I turn it over to Mr. Solis, is one of the issues in this regard of the SIR board that claimant argued in their presentation, as they do in their papers, is a board of directors meeting in 2011, through which they supposedly decided to invest.
Yeah, but I think you're going much more. The question was, what is the relevance or non-relevance of the fact that the members of the board who are Italians do not have an interest or a participation or shareholding in the company? That's the key question. That's the specific question I asked for from claimant.
Just very concretely, if they are otherwise strangers, and by strangers I mean not economically interested in or invested in an entity, whatever passport they hold cannot be the basis to hold that entity as foreign for purposes of jurisdiction.
Thank you. Just very briefly, Mr. President, if I may. Briefly, sorry, excuse me. Just the ICSID Convention protects investors, not board members. If this was a case under Article 25A, which is not, but if it was, the investors here would have to establish that they have made an investment for purposes of Article 25, and that would not be established by simply saying that they sit on a board. The convention protects investors, not directors or boards.
Okay, the other question that I had is if we can go to, it's in various slides, but just for purposes of this exercise, if we can go to slide 98 of our claimant's presentation. In several of these slides, you refer, you say Italian shareholder and then proxy shareholder. What do you mean by proxy? What does it mean?
Sorry. The proxy shareholder is the one who was empowered by the shareholder to vote the shares at the annual meeting. So, if I own shares in Amazon, I don't necessarily show up at the annual meeting. I might sign a proxy to have somebody vote them for me.
So the individual voting is voting on behalf of whoever gave him the proxies. Is that the
Yes, Mr. President. And for example, just the one down at the bottom, Traverse Atlantic Corp., which is one of the entities involved, the BVI and Cayman Trust that we're going to hear expert testimony about. Traverse Atlantic Corp. Gave a proxy to Carlos Pellis to vote the shares, his shares, held through that structure.
Okay. Okay, thank you. 12:40, we're going to take a break until 1:40, and we'll resume at that time.